And we are live. Hello everyone, welcome to the Alien Spaceship stream. You could be watching from anywhere around the country or the world, and I really appreciate every single one of you coming to you from the spaceship studios from a galaxy far, far away. Alright, so hello everybody. We are going to be switching over to the other screen. Alright, so it's Alien Spaceship. I hope everybody's been having a good day so far. I do not see any trials that I'm aware of on, and I usually sometimes will do these surprise lives and react to some trials that I'll either do a trial that's on or a trial that we haven't seen yet, or a trial that we have seen from a long time ago or recently. We've been doing Johnny Depp trial reactions, and we probably will do some of that today too. I'm going to do the... Hello, Sharon. Good afternoon. Good to see you. And... oh, something I remember from one of the trials that... maybe you've seen this or watching recently. That you may have seen it on another channel. There's a situation that happened where in one of the interrogations, the officer or the investigator was telling the defendant that he was going to be dodging Deke in prison. So a new one that we added is dodging Deke. So there's free Deke, there's crook Deke, and there's dodging Deke. So that was quite funny. Yeah. And it's good to see you. Sharon's been a little bit since we've seen you. All right. And I saw Abby yesterday, and she's been going through a lot, but she's hanging in there. It was nice to see her yesterday. Alright, so we're going to do this reactions right here. I'm going to play some of this funny trial stuff. Oh, you've heard that. Yeah. Alright, let's see. Okay. Let's start off with this. Going this way right here. Alright, so we're going to be switching over to the other screen. Oh, hello Mary Toodles, good to see you. Yeah, we've been going to go here. Alright, so we got the angry Darrell Brooks. And this is another comedy type trial. It was certainly very comedic. And I thought it was... and we've been reacting to it. And some people that have never seen this trial before are seeing it for the first time that we've been showing. And they're quite marveled by him. And this trial happened, I guess, November of 22. It was 22, but it was like around November. So the same year of the Depp trial, but are closer to this time of year. All
right. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that.
Mary, I am glad to see you. I am. And you see, Darrell Brooks, he has a he has a Timu Stonehenge face to him. That's what he has, a Timu Stonehenge. Scared.
To me, if jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. I'll have the jurors report on Monday at 9 a.m. Thank you. You are excused. Please rise for the jury.
yourself a judge as much as bias you put up in here. Don't even tell the jury the truth.
Hear that, chat? She doesn't tell the jury she doesn't tell the jury the truth. Oh yeah. So recently he had. Yes, Mary Toodles is the judge. That's true. And yeah, Mary Toodles and Darrell look like twins. They do. And yeah, it's a Temu box for it because this recently he had a hearing and he was in a the Temu warehouse where they have a bunch of boxes and he had his mouth covered and they think that he got punched in the face or he got his nose broken. That he was more calm, but yeah, that was very wild. That was very wild. Definitely. And yeah, he's about to explode, and it's gonna be scared. All right.
Got no integrity whatsoever. None. None.
Thank you, everyone. Please be seated. I would like an update on whether Mr. Brooks filled out a subpoena for Dawn Woods and provided that to the state. Has that been done?
No, we haven't received anything, Your Honor, and obviously she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary. We had subpoenaed her and she was under a state subpoena. So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If I want her to be here, she gonna be here.
I agree with
So
the state that.
Just know that.
She could certainly appear.
It ain't even got to be no arrangement. All I got to say is come. She gonna come. That simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you to have her here at 9 a.m.
We said all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a
Mr.
judge?
Brooks, I need to make a record of some
I need to make a record too.
You don't.
When am I going to get the chance to do that?
All right. I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make. He hasn't sat down for the better part of 2 hours.
All you want. You can hold me in contempt all you want.
I'm not holding you in contempt.
If it's criminal or civil, so I can hit you with you.
I need to clear the courtroom because I do need to
I'm gonna give you what you know is coming.
I need him to go to the
If
other
it's civil,
courtroom because I do need to put some things
if
on the
it's civil,
record. The record should
Where's the
reflect
contract between you and
that
I?
Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the crime?
He is.
Who makes the claim? And what
He
is
is. I will make the record when we get back. I will step off, but Mr. Brooks, you're being
It ain't
taken
no,
to the next
It ain't no Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's system.
Yeah, and Murray says, is he mentally unstable? Was he evaluated? I don't know if he was evaluated, but I know that he was certainly medicated after this in different trials. But yeah, he fired his defense. And exactly, Sharon. When he fired his defense, and he's pretty crazy. Like, he drove into a crowd of people in a Christmas parade, and he has a lot of like hatred in him. So yeah, he certainly has a problem, but his character is just really corrupted by his own ego, and yeah, I'm not too sure what his evaluation would have been, but he was sane enough to be put on trial like this. He fired his own defense, and he defends himself. All right, let's go to the next part. The sacred clock and the eagle. All right, here we go. Mary Toodles right here.
Appropriately. I need to address some scheduling issues, but before I do that, I need to make a record that at the very end of
Well, you remember when it happened? Yeah, I remember watching it while it was happening back then. Yeah.
I read the closing instructions. Mr. Brooks started to make disparaging remarks about the court in the presence of the jury. I did not respond to those. And once that jury left, he got incredibly loud. He was yelling at me. He, I think, had been standing for the better part of the last couple of hours, even though at one point I directed him to sit down after the direct examination of the last witness. It was apparent to me that he was not pleased with some of the rulings that I had been making regarding objections. I would just remind him that this was a witness he called, therefore it's proper and allowable under the law, under 906.11, sub 3 to be exact, for the state to ask leading questions, which they did. And at the very end of that, there was an objection based on badgering, which, as the record reflects, I sustained. His voice got louder. He continued to stand. He was being very argumentative with that witness who, again, he called. Given his posture, given his staring, given his pursing of his lips, given the way that he kept asking the same question in different ways, but over and over, not satisfied with the responses that had been given or the court sustaining the objections, that is why I made a finding at that time and sustained the objection for badgering. It was Mr. Brooks who asked me what that meant, and I indicated it's a form of intimidating a witness. I don't mean that in the sense of there's a charge of intimidating a witness. That's not certainly what I meant, but really in the common everyday usage, it's another word, it's a synonym for badgering. Clearly he was displeased with the court. After that, I cut off the examination, which I had given a number of warnings that I would do if he didn't ask an appropriate, a probative, a relevant question. During that time of both the, frankly, even during his direct examination, definitely during the state's cross-examination and then redirect, it was very apparent to this court, and I think to anyone who was watching, that Mr. Brooks was not pleased with the witness's answers and would roll his eyes at her, or just to himself, I guess, and purse his lips and make other gestures that he did. That it was apparent to this court he did not like her testimony. And again, I'd remind everyone that it was his witness, and he had the police reports for this witness. And obviously was fully aware of her statements to the investigators in this case. So I just wanted to make a record of that. It's in part why at the very end, and given the history of today and his conduct and being removed previously, I thought it important that the court remove him at the end of the hearing outside the presence of the jury so that I could get through a couple of things. We have gotten through the witnesses for which Mr. Brooks issued subpoenas that the state assisted with. I did provide permission to him earlier today, if he so chooses, to call Dawn Woods as a witness. The only other witness at this point that I can identify that's been for which the court and the state has been put on notice, of course, would be Mr. Brooks himself. I'm not looking for an answer today, but what I wanted to put on the record and what I will put on the record are certain advisements that he can certainly contemplate over the weekend so that when I do the colloquy with him on Monday morning, he's had a sufficient opportunity to think about his decision to testify or not to testify. The advisements that I will give Mr. Brooks at the moment are as follows. Mr. Brooks has a constitutional right to testify. If he chooses to testify, I'm further advising him that the state has the right to ask questions of him.
I remember this part where, hello, Roxy, good to see you, welcome. Yeah, I missed you too, Roxy. It's good to see you again. Yeah, so in this part, they're talking about how Darrell Brooks was going to be testifying, but what they did was eventually, I don't think he ever testified, but everything he did, he buried himself deeper and deeper. Now, over here, see, he did a rant right here. Which this is quite insane. Let's see. Let's see what this is about.
Or as they
Yeah, this is one where he did a rant for a little while. Or reacting to scenes in the Darrell Brooks trial and watching Darrell Brooks cringe along with other parts of the trial as well. All right.
Is available?
Yes, Your Honor.
All right, let's bring the jury back out.
I don't consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party intervener on special appearance on behalf of my client. Can that be noted for the record?
Was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
The appearances are as they were this morning. They are no different. Bring the jury out.
And we have yet to address subject matter jurisdiction, Your Honor. I still haven't been shown any verified proof that
All rise.
this court has subject matter jurisdiction. And at this point, may I request an affidavit that you, Your Honor, have no bias, no conflict of interest, and no interest in the outcome of this case?
Mr. Brooks, the jury's coming out. We'll address your legal issues later, if I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the
please,
state, or is this the
please.
military
All right,
power?
Can you please take the jury out? Thank you.
And Liberty, this is from the same year that the Depp trial. It happened. A person drove a SUV through a crowd of people in a Christmas parade, and he fired his defense, and he was defending himself. And he makes a spectacle of himself. And the judge is very, very patient with him. But yeah, he is his own worst enemy.
Do you hold the full
Mr. Brooks, just
jurisdiction?
wait till the jury's out, please. I ask that you show that respect.
I will.
Thank
Your
you.
Honor.
Just make your statements. What do you want to advise the court today?
I want to first state again for the record that I do not identify by that name, nor do I consent to being called that name. Your Honor, with all respect,
He thought of himself as a sovereign citizen, so he did not go by his name Darrell Brooks, because it's the name that the state gave him. So he was trying to claim that he was, like, outside of the law. Exactly, he's going to get the smackdown. Yeah, fact sharing. Yeah, so that was the reason why his name is Darrell Brooks. He doesn't want to be called by the name Darrell Brooks.
merely asking you, do you have the full judicial power of the state, or is this military power?
I'm sorry? I don't understand what you're asking me, sir.
I'm asking, is
And on what
this,
legal basis are you making that request?
I'm asking, for the record, is this a common law court or an admiralty court? What are we in here? And I'm requesting an affidavit that you, Your Honor, have no bias, no conflict of interest, or no interest in the outcome of this case. And the reason why I want to state this clearly for the record, mainly is because of the bias that's been shown. I have not been getting any certified copies of any requests that I've made, which I was told by this court to address inmate communication forms for anything that I may need. I've done that. I've complied with that. Every time I've needed something of the court pertaining to documents, I've done it the way the court has asked me. And I've always stated that I wanted everything to be certified. I have yet to even get that. My court docket sheet was not a certified copy. When I asked Your Honor of your oath of office, I asked for that to be certified. You stated for the record that you would not give me a certified copy of your oath of office, which you are required to show if I ask for it. I've brought up my Sixth Amendment constitutional right that has been pretty much discarded, and that is based on the fact that I have the right to face my accuser, which would be the plaintiff, state of Wisconsin, in this matter. They have yet to show that a claim is I mean, a living human being can only make a claim. An entity cannot make a claim. I've requested for the complaint to be provided. The complaint from November 23 of 2021. The amended complaint from November 29th of 2021. The second amended complaint from January 12 of this year, 2022. I have yet to see those. There was no record of a bond in my docket sheet. I asked for that to be verified by proof. That hasn't been provided. There's so many biases, clear biases in questions that are not being asked based on judicial determinations made by Your Honor. You look at the discrepancies, and I think they're clear. I think at minimum I deserve for the subject matter jurisdiction to be verified and proven. I've raised that issue numerous times, pretty much every day, every time I come before your court, Your Honor. I address that, and it has yet to be proven. My filings have been disregarded, even though they've been filed into the record, even though they've been time stamped. I haven't got the original copies of any of them, which I'm supposed to get. And as we sit here today, I'm still not even understanding the nature and cause of the charges. That hasn't even been proven. Can that be provided in any way? I'm basically sitting here confused because I don't understand why these proceedings are allowed to continue when there's so many things that have not been provided. They haven't been provided in my discovery. They haven't been provided to me by being brought to my pod where I'm housed in the jail. I'm without so much information, valid information to this matter. And I believe that it should be verified and it should be proven for the record. And if not, I move for this case to be dismissed for failure to appear by the plaintiff and failure to state a claim for which relief can be granted. Everything that I'm saying, it has merit and it has validity. As we sit here today, I'm still being charged with charges that shouldn't even exist based on the testimony that we've heard for the last few days. There's so many things left to still be proven. The prosecution team hasn't even proven that they're licensed to practice law in Wisconsin. They haven't proven, are they just bar association members, or do they have state issued licenses? That has not been proven, which I've raised that issue for the record. I'm not even sure if that was even recorded in the docket sheet. There's so many things, and Your Honor, you still haven't stated for the record if you have full judicial power of the state or is this military power. That hasn't been proven. Nothing has been proven. Not subject matter jurisdiction, not licenses to practice law. My Sixth Amendment right has been basically trampled over. No complaints have been shown. Neither of the three that I've requested, by the way that you told me to request them by inmate communication. Nothing gets certified that I get copies of when I clearly ask for them to be certified and to be filed into the record. It's to the point where Your Honor, you should recuse yourself from the presiding at this point. If you're not going to abide by the oath that you swore, which was in your oath, correct? You swore to protect the Constitution of the United States. You swore to protect we the people. That is not being done here. If every valid argument that I raised is taken by the court as a sign of disrespect or a sign of trying to intentionally be disruptive or causing a problem, when I'm merely seeking understanding, because I don't understand. I'm merely seeking to understand why this information has yet to be provided and we're this far into this matter. And there's still no verified proof. Even as I sit now saying this, there's still no proof being provided. Zero. How is this case allowed to continue without these documents and filings being verified? Is there any legal factual basis that can state why this information has not been provided? Why the docket sheet is incorrect? Why there's so much on the docket sheet that should be on record that's not even in there? That if we had the recordings of the record, they would see was brought up numerous times that doesn't even show up. I'm just asking for Your Honor to be fair, which is another right that I have, the right to a fair trial and the right to an impartial jury. I can go on and on and on about what's not being done. I have, again, I say I have the right to face my accuser. Where's the injured party? Who's making the claim? I asked Your Honor numerous times for Your Honor's name. You wouldn't answer. I asked, did you have a claim against me? You did not answer. I asked the whole courtroom, did anyone have a claim against me? No one said anything. Which you stated for the record a non-responsive answer. A non-responsive answer is an agreement, which will be a tactic agreement by you, Your Honor, that you don't have to answer these questions that you should be answering. I have that right. The plaintiff in this matter, which was stated by witnesses in testimony to be the state of Wisconsin. But when I ask, do they see the state of Wisconsin present in the courtroom, the question is shut down, which is a valid question. The plaintiff should be present in this matter. Where is the plaintiff? Who's bringing the claim? Because we know an entity can't bring a claim. It has to be a living, breathing human being. No one is stated for the record if they're the injured party. Not Your Honor, not the prosecutors, not anyone in the court has stated to be an injured party in this matter. No one. Not one person. I have the right to demand that the court place into evidence any unrevealed contract. Has that been provided to me? Have that been placed into evidence? I would like to see it, which is my right. I have the right to inform the jury about the truth and their duty and their rights. That's the First Amendment and the Sixth Amendment. But I'm repeatedly told to shut the question down when this is valuable information that the jury should be privileged to know. They deserve to know. Once they were chosen to sit on this jury, why are we keeping information away from them that they deserve to know? They ultimately have the power. They decide the matter. Why are we keeping information, valuable information, from their knowledge? That's a disservice to the jury. And frankly, it's a disservice to the court that they're not allowed to hear things that they should know, that they should be informed of. It's our right to inform them of everything that they have the power to know, to do, and to know. They deserve that much. It would be a travesty for them to make a decision without being fully informed. And these are all valid things. I have the right to protest and object if any of my rights or demands are not being met. I've done that numerous times only to be shut down. Numerous times. I've raised the issues that I didn't consent to anything that may have been suggested on behalf of my former attorneys. I've never even consented to them making a plea on my behalf. I haven't, as a matter of fact, when it comes to a plea, I haven't even had the opportunity to entertain any plea that may have been suggested by the prosecution. We haven't even talked about that. Not one time was it ever brought to my attention that the prosecution even wanted to offer a plea. That's another issue. I have the right to challenge the jurisdiction of this court, which I've done numerous times. I have the right to demand that the code be construed in harmony with the common law. I just raised that. I'm constantly referred to as pro se when I've raised the issue that I'm pro per. I have the right to conduct my defense pro per, free from professional restrictions imposed upon licensed attorneys, which this court is well aware that I am not a licensed attorney. In fact, the court is also aware that I only had 3 days to prepare for a trial that the prosecution has been prepared for a whole year. We see these boxes right here. This box alone is 45 or 50 pounds full of so much information. I haven't even gone through half of it. It was stated for the record that the discovery, in its entirety, was brung to my housing unit on the 29th of September, which trial was scheduled, that would be a Thursday, which trial was scheduled for Monday. How can I possibly go through all that, all the paperwork, all the digital discovery and things of that nature? How can I go through all of that and be prepared in 3 days? That's a clear bias. I did not have time to prepare for this. Everything I'm doing is off the top of my head, winging it. taking it as it comes. When the court is well aware that I was not prepared, I raised the issue that it should be an adjournment, at least at the minimum, it should be an adjournment because of that fact. At least to let me go through all the discovery. That was denied. No valid reason was stated for that when Your Honor knew there is no possible way, humanly possible, that I could be ready for a trial of this magnitude in 3 days. That's clear bias. I have the right to face the injured party claiming damages. That's under Article 3 and the 6th Amendment. I raised that issue again. Where's the injured party? Is the injured party present in court right now? Can anyone make a claim against me? Can you make a claim against me, Your Honor? Do you know of anyone that can make a claim against me, Your Honor? Can anyone right now in court, anyone, make a claim against me? And because of that, Your Honor, the motion to dismiss should be granted based on that alone. There's no injured party in this matter. So who makes the claim? Who? I have the right to put the judge on notice of my intent to appeal and any ruling decisions during the case. You stated for the record that I would have to wait until appealing process, but my right is that I can raise that issue during the case, which I've attempted to do. That's been shut down. I have the right to specifically reserve all of my rights, which I do at the beginning. I have the right to say what I want and to be heard under the First Amendment. And when I attempt to do that, it's taken as a slight to the court, a disrespect to the court, or me intentionally coming into the court to be disrespectful, which I've stated that is not my intention. Never is it my intention. I never intend to walk into your courtroom, Your Honor, and be disrespectful intentionally. I never come into this courtroom to disrespect anyone. But because I don't understand, I raise these issues because they have validity. I have the right to object to any statement made by the judge or the prosecution. I've done that and been repeatedly shut down. Without done legally, I've been denied that numerous times. Based on that alone, there's no injured party in this matter. So who makes the claim? Who? I have the right to put the judge on notice of my intent to appeal and any ruling decisions during the case. You stated for the record that I would have to wait until appealing process, but my right is that I can raise that issue during the case, which I've attempted to do. That's been shut down. I have the right to specifically reserve all of my rights, which I do at the beginning. I have the right to say what I want and to be heard under the First Amendment. And when I attempt to do that, it's taken as a slight to the court, a disrespect to the court, or me intentionally coming into the court to be disrespectful, which I've stated that is not my intention. Never is it my intention. I never intend to walk into your courtroom, Your Honor, and be disrespectful intentionally. I never come into this courtroom to disrespect anyone. But because I don't understand, I raise these issues because they have validity. I have the right to object to any statement made by the judge or the prosecution. I've done that and been repeatedly shut down. Without a lawful explanation. I've repeatedly asked the court for a motion for a finding of fact to determine if things are being done legally. I've been denied that numerous times without merit, which is also my right. I have the right to recuse the judge at any time, which is also a right. I have the right to a speedy and fair trial by impartial jury. I think it's safe to say that my speedy trial right has definitely been violated because this matter has been taking place for roughly a year. I've never consented to waiving anything related to a speedy trial. And if that was done, it was done without my consent or without my knowledge. We're way past the speedy trial date. Way past. When the change of venue motion was brought up, I believe that was the first time I came before Your Honor in early March. I want to say March 11th of this year, when the change of venue motion came into play. It was decided by Your Honor that wouldn't be decided until the 20th of June, I believe. That's over the 90-day mark right there for a speedy trial. That was denied, and I still don't understand how that was denied when it's clearly obvious that at minimum the venue should have been changed based on the fact of the magnitude of the matter. There's no possible way anyone in this county would not have some type of connection or some type of knowledge, whether they were told something by someone that they may know. The news reporting alone, just that alone, there's no way that this trial should be taking place in Waukesha County. That's obvious. That's obvious from the way the motion was presented, the coverage alone, the political campaign ads that plastered the defendant's face all over the TV every single day. Every time a political campaign was brought up, it made reference to this incident. Every single time. The fact that people have children that go to the same schools in this county, that people may have worked with the same people in this county. You yourself, Your Honor, stated that you at one time worked with the father of one of the people that was injured in this matter. That is a clear conflict of interest right there. You also stated for the record that not only did you work with this father, but that at one time they may have donated to I don't know if it was to you becoming a judge, or I would have to look through the docket, but you said it on the record that they donated money to a cause of yours. You also stated that when you had gained knowledge of the incident and that their family member was injured in the incident, that you reached out via phone. I don't recall if it was text message or an actual phone conversation, but you put that on the record. You also stated that the nature of your relationship was strictly professional. I don't know about you, Your Honor, but I've worked numerous jobs, and I know what professional relationships is and personal relationships. I've never had the cell phone number of anyone that was a personal relationship saved to my phone that I can reach out immediately when I learn something. that would constitute a personal relationship of some kind. Whether hanging out from time to time, having a cup of coffee, or hanging out time from time, grabbing a beer, or hanging out from time to time, watching a game, or anything of that nature. It would definitely be more than just strictly professional. That was stated for the record. Again, I go back to the Sixth Amendment again. In terms of when I asked for the motion for the evidence motion that I raised, that was denied without any explanation. That would be strictly to place in the evidence any unrevealed contract. That's under the Sixth Amendment. Clearly, there's been repeated violations of my Sixth Amendment. We all know that the United States Constitution is the law of the land, period. It trumps everything. We also know that any law repugnant of the Constitution is null and void. We know that. There's still no basis for the motions being shot down. Why was I not granted the motion for finding a fact? Why did it take so long for me to be brought my entire motion for discovery? Why was the motion to prove jurisdiction not verified? Why was the motion to dismiss the case for all the reasons I said not being granted? Which brings me to the motion to subpoena witnesses. I did everything that was asked of me by the court pertaining to those subpoenas. It was understood by the court that this is my first time ever having to do this. I didn't understand how to properly fill out the subpoenas, at which the prosecution volunteered that they would give assistance. The only assistance I received was for them to check to see if it was filled out right. That was it. That doesn't amount to any assistance. I was still left to fill it out on my own, and then when I did that, corrections still had to be made, which would verify what I was saying. I don't know how to do this. But I still complied to what the court asked of me. And even then, it was a big old thing about the subpoenas. I can't subpoena the plaintiff in the case. Well, how can I not subpoena the plaintiff in the case when under the Sixth Amendment, I have the right to face my accuser, which is the plaintiff of the case? So how could the subpoena not be filed? And how could the plaintiff not be called to the witness stand? That begs the question of, does the plaintiff even exist? Which it was stated for the record that not only by a witness, a Detective Casey, that got on the stand and said on the record that it is an entity, which is not a living, breathing human being. And then it was stated again by you on the record, Your Honor, that the plaintiff is an entity. So the question still stands. How can an entity bring a claim if it's not a living human being? So where's the claim? Will the plaintiff in this matter, the state of Wisconsin, be allowed to testify? Will they be allowed to be in the courtroom? No, they will not, because they don't exist. Therefore, the claim doesn't exist. For all those reasons that I just stated, the case should have been dismissed a long time ago. Once those issues were raised, this case should have been dismissed. And at the very minimum, it should have been dismissed because those still have yet to be proven. We're still talking about jurisdiction. That's been being asked for over a week. There's still no providing of license to practice law yet. Not even by you, Your Honor. Why was I not provided with a certified copy of your oath of office? Why would you not state the name that is on file with the Secretary of the State? Or I made reference the first time to the Secretary of the Treasury, and then you stated on the record that it's the Secretary of State, even though you knew what I was referring to when I asked. You referred to your name tag, but that's not the name registered. We both know that. So why wasn't that proof verified? You gave me a copy of your oath of office, but it is not certified. So how can I verify that that is the true oath of office that you signed? How can I verify that is valid? That's the reason why I asked for it to be certified, which you stated for the record you will not do that. You never stated any legal reason why. I have the right to ask for that legally. I also have the right to call any witnesses to assist my defense, which is the main reason why I subpoenaed the plaintiff in this matter. I also have the right to challenge all relevant laws in this trial in terms of their intent, interpretation, fairness, enforcement, and whether they serve and protect the people. From my knowledge, the design of the statutes of the law was written for the common people to understand. So that would mean the final determination or interpretation of what the law says comes down to the people. You know this, Your Honor. Are you not a public servant? You also know that this docket sheet is inaccurate. Every filing up until the point that I started representing myself was filed in a name that was represented by all capital letters, which is not my name. Nor has it ever been my name, nor have I ever seen that name or individual. Every single filing or paperwork was all in capital letters. Ever since September 29th, roughly around there, now everything starts to go to lowercase letters. Why is that? What prompted the sudden change? I still have filings that have all capital letters, which I state every time I come into your courtroom, Your Honor, that is not my name, nor do I consent or agree to being called that name. I'm merely here as a third-party intervener on behalf of my client. Did I accept for value in return for value? We go through this every time I come here. Every time. You bring up Illinois versus Allen when we had the issue of me being removed from the courtroom. We went through that where Illinois versus Allen states that there are 3 options when a defendant is being disruptive in court. You stated for the record that you identified a 4th one, which is not cited anywhere in that case. It's not cited anywhere. So the question would be, how did you come up with a 4th option that's not written in that case? Did you take it upon yourself to add this 4th option to justify denying me my constitutional right by being present? You could have done the 3 that were stated. Any one of the 3 you could have done that were stated in the case. Nowhere does it say you can create a 4th option. Not upholding my constitutional rights. I'm sure you know about Title 18, USCS 2381, which states that it's treason not to uphold your oath of office. Treason. You repeatedly make judicial determinations that clearly prejudice my defense. And then when I question you about, are you making judicial determinations, I'm repeatedly shut down. Which leads to today. The constant push not to have an informed jury. Not giving legal valid grounds on objections. Not noting objections for the record to make sure that the record is clear. I'm sure somewhere in the jury instructions, you informed them that the state of Wisconsin was bringing a claim. But then you make the judicial determination that I'm not allowed to ask questions about the plaintiff. That's clear bias. And it prejudices my defense. You know also that you have an electronic filing system. I find it hard to believe that I was told yesterday about my subpoena for the plaintiff that I had to wait for a filing in a timestamp when I've seen it done numerous times in just a few seconds right in front of my face. When the prosecution needs something filed, it's filed immediately. I have to wait, or I have to wait till the next day. That's a clear bias and a clear prejudice to my defense. Obviously, the court knows that I'm not privileged to the same filing system. Which brings me to the reason why I brought up the issue of assistance of counsel Under the Sixth Amendment, I have the right to assistance of counsel. It doesn't say anything about representing yourself without assistance of counsel. Having counsel represent you and having assistance of counsel is two totally different things. You, Your Honor, gave me paperwork that was a waiver of counsel. We both know that any contract can be altered if I don't agree to certain terms. I crossed out everything in that paperwork that I did not agree or consent to, and specifically wrote on that paperwork that I do not waive my right to assistance of counsel. At the very least, I should have been awarded a standby counsel. Not someone to represent me, to speak for me, but someone to help me do things in a timely fashion. Get things filed in a timely fashion. Get motions together in a timely fashion. Make preparations to get things done that I don't have the privilege to do in my current situation of being housed at the Waukesha County Jail. I gave you back that paperwork and you accepted the paperwork that I altered, that you understood that I didn't agree and consent to those things that were altered. You accepted it and you filed it. That is in the record. I have copies of the same paperwork that you accepted. So when you accepted that, with no objection, that becomes a tacit agreement. But yet, I'm still forced to come in here with zero help. I think it's clear that prejudiced my defense. Knowing that the prosecution has everything that they need for this matter at their fingertips. And I have to jump through every hoop possible to even get things filed in a timely fashion. It was stated for the record that the unit that I'm housed in the Waukesha County Jail, and per jail administrator Angela Wallenhoff, that I'm only allowed out of my cell for a few hours a day. So I'm roughly locked down 22 hours a day. Not given the privilege to access everything that I should be able to at the time that I should be if I was general population. Arrangements could have been made months ago for me to be at least in some form general population with an upcoming trial. Reference was made to being able to use LexisNexis or whatever it's called. We call it the law library. That may be the easier way to describe it. I'm only allowed to access the law library at certain times during the day. The rule of the jail is that when you're not in the day room, you can't access the law library, which is on tablets. We are not allowed to have those tablets in our cells. That prejudiced my defense. How can I work on my case? How can I look up certain case laws? How can I do any of this if I don't have full access to it? I even suggested some type of order that could be made by the court to allow me more time out of my cell, or to talk to jail administration about allowing me more time out of my cell to be able to use those when needed. And to be frank, in a proceeding of this magnitude, there should not be even a time where where I don't have access to the materials that I need. If I'm not in the courtroom or sleeping, I should be awarded the time to work on this case, seeing as how I only had a couple days to prepare for a trial of this magnitude. Which brings me back again to the change of venue again. Even right now with trial going on, there's still political ads being shown every day that reference this incident. There's still talk throughout the jail about it. There's been a ton of hate mail received to the jail since the beginning of this. It did die down for a little bit, but it picked right back up the closer we got to the trial. Hate mail that comes from people right here in the city of Waukesha. Which gives more credibility to the venue needing to be changed. Yet and still that was denied. It's impossible for impartial jury to be found in this county. And that's not to discredit people in the county that can be impartial. It would be unfair to say that no one can be impartial. That wouldn't be accurate. But with the level of scrutiny that this whole incident has, the reporting, the Facebook groups, the constant, there were Facebook groups created because of this. The reporting live stream on Court TV has comment sections where a lot of insensitive and nasty things are said. The sheer insensitivity of some of the things that are said on there. I know a lot of people probably don't care about what I'm about to say, but it still needs to be said because it's truth. The fact of the matter is, that I have children too. Family too, loved ones too. That also have been ridiculed and had their names dragged to the mud and have threats towards them. Loved ones that had to leave their home because they were getting threats thrown through their mailbox. Children that didn't feel safe going to school because they were getting bullied behind what was being said. And that's not to sweep anything under the rug whatsoever. To constantly say and report this incident as attack, terrorism. It's unfair and it's insensitive. It's a definite tragedy. Definite. And that will never be swept under the rug. There's always going to be healing that has to take place. it's going to be difficult. And that should not be swept under the rug whatsoever. But it's very insensitive and unfair to not recognize that there's many, many, many other victims that never is talked about. And for people to paint a certain picture, mostly from this county, to put this picture out there, it's not only hurtful, but it's insensitive, and it's not true. I'm sure the court read through the motion for change of venue. I'm assuming, though it was a lot of paperwork in those motions, I think it was obvious that the venue should have been changed. Obvious. It's too many connections and it's too close. It's too close. If there was any chance for a fair trial and an impartial jury, it should not have been in this county. But yet it was denied without any validity. Zero. There's so much bias that's going on that and even with all this, for the record, we still have no proof of jurisdiction. We still have no bond on file in the docket sheet. We still have no plaintiff. We still have no claim. We're not sure of the relationship between you, Your Honor, and a father of one of the people that was injured. We're not clear on that relationship, no matter how well prepared the speech was, because it was a prepared speech. That was obvious. Where's the proof? I just asked that same question. Can an affidavit be given that there is no bias, no conflict of interest, and no interest in the outcome of this case? There still is no proof if you hold the full judicial power of the state, or is it the military power?
Mr. Brooks, I've given you about 50 minutes to make your various arguments. You've now repeated yourself a number of times, so I'm going to turn to the state to see if they have any response. Go ahead.
Thank you, Judge. Judge, I'm going to summarize what I just heard by quoting from a case from the Eastern District of Wisconsin, federal case found at 2022 Westlaw 3045190.
Can you repeat that last
I'm so sorry. 3045190. Retzloff versus Moran. This case is talking about many of the topics that Mr. Brooks has now recited to the court, and simply states, the majority of Retzlaff's filing is incomprehensible jargon and cut and paste legal mumbo jumbo. Sovereign citizen theories are frivolous and wholly without merit. And the court goes on to cite to Bay, B-E-Y, versus the state of Indiana at 847, Fed 3rd, 559, on pages 559 through 560, a Seventh Circuit Court of Appeals decision from 2017. Mr. Brooks knowingly.
I consent to being called that name, nor do I know any individual by that name, Your Honor.
Please do the courtesy of not interrupting the state, as they did not interrupt you for over the almost 50 minutes that you spoke. Thank you. Please continue.
Your Honor, the record is very clear that Mr. Brooks knowingly, willingly, voluntarily, and intelligently insisted on representing himself in this trial. He has no constitutional right to stand by counsel, none whatsoever. The court patiently went through the form and advised him of many of the things he's complaining about here today: the resources of the state, the knowledge of the law, his ignorance of the law. And his words to this court, and I quote to the best of my ability, "It don't make me flinch one bit." That's what he told this court, whatever it was, 2 weeks ago. Now he's here complaining over and over and over again how unfair this is to him. It's highly offensive. I don't know, because unfortunately I was talking to my investigator, if he accused this court of treason, but I certainly heard that word come out of his mouth, and it is absolutely shocking that he would throw such a word around so loosely in this courtroom. This court has been exceedingly patient, exceedingly respectful of his rights at every turn. At every turn. I want to address this claim that he only had 3 days to prepare for trial. It's absolutely a false statement. The record should reflect that he does have 3 banker's boxes on his table. The record should reflect that every time the state calls a witness to the stand, he swiftly and easily turns to those boxes, which appear to be alphabetized or organized in some fashion by the public defenders who turned it over to him, and quickly removes the folder of the witness who's testifying and effectively cross-examines that witness using notes from the public defender. We know that because he's tried to confront witnesses with the notes from the public defender. He is not going into this blind or with one arm tied behind his back. They did all the homework, and he's simply sitting here reading their notes, reading their cross-examination questions, and asking the questions, and then going on to his ridiculous questions having to do with his belief in the sovereign citizen movement. There's no way this record would reflect that this defendant is not adequately prepared for trial. He's never asked for a speedy trial. He makes conflicting statements. On one hand, you violated his rights because it's taken us so long to get to trial, and on the other hand, we're rushing him to this case and he hasn't had adequate time to prepare. He is not denied access to legal materials in the jail. The record is very clear from the jail administrator. It should not be confused. He misleads this court intentionally to say, I only get out of my cell 2 hours a day. That is a fact. That is for his own safety, so that other inmates do not inflict physical harm upon him. He has access to a tablet. He has access to a computer. Whether he chooses to ask for those resources is up to him. I would also cite the court to U.S. Ex-Rel George versus Lane, Lane, 7th Circuit Court of Appeals at 718 Fed 2nd 226, where a pro se defendant attempted to complain on appeal about his lack of access to a computerized legal research system, paralegal training, or law school education. The court rejected that contention and said, once a defendant has asserted his right to refuse counsel and conduct his own defense, he has no constitutional right to access those resources. And again, you warned him, Judge. You fairly warned him. And he basically acted as if you were insulting him and said it didn't make him flinch one bit. Much of the last 50 minutes, which this court has graciously extended him the opportunity to go on and on and on, is nothing more than legal mumble jumble. He's reading from some typewritten transcript. I can see that from where I'm sitting. I don't know who's giving him these materials, but he has an agenda here. It's to stall, delay, disrupt, intimidate, and it's not going to work. Thank you.
Objection to that. Your Honor, that's a load of crap.
Mr. Brooks, that's my opportunity now. I gave you about 50 minutes.
I just want to object to the disrespectful comments that was just made. I'm not trying to hold you up from what you're gonna say, but that's a load of crap.
Mr. Brooks,
for her to sit there,
Mr. Brooks,
for her to sit there,
objection is noted.
for her to sit there, Your Honor.
No, it's my turn. Let me go through this. I graciously gave you 50 minutes to raise all these various points that you want to bring up. I then gave the state an opportunity to respond. That is the proper procedure. I followed decorum. I followed civility. I did not interrupt you. The state did not interrupt you. Your objection to their characterization, it's noted for the record. I am going to render a decision at this point. Please listen, and please do not interrupt. As I indicated, the defendant spoke for about 50 minutes, raising a litany of complaints and issues and theories regarding his view of how this case has proceeded. Many of these issues, if not the vast majority or even all of them, have already been addressed by this court in one way or the other. Looking at, for example, his complaints about change of venue. It is true this court denied the change of venue motion. The court made a record at that hearing. I stand behind that record and that decision. The arguments made regarding that decision, which I would note he has yet to file an interlocutory appeal challenging that, are nothing more than speculative, without a basis in law or fact. To say that this jury is biased would be a complete miscarriage of justice and a mischaracterization of the process this court painstakingly took in order to obtain a fair and impartial jury. There is absolutely nothing on this record before the court throughout these proceedings to suggest that this is a biased jury. I stand behind my previous determination and the process that this court went through, including initially calling an unusually large panel for which the clerk of court's office sent the initial qualification questionnaire, and then ultimately a case-specific questionnaire was sent to approximately 1,400 jurors or potential jurors. There was ample opportunity for the parties throughout the proceedings leading up to the end of August to review those materials. There were numerous strikes for cause that this court entertained. Even prior to that specific hearing, the parties met, they conferred. The state agreed not to challenge the vast majority of the challenges to jurors brought by the defense. Then there was the hearing. Then this court, at jury selection, allowed for an indefinite number of strikes for cause. Many were granted, if not all. And then even on the day that the jurors were brought in, the court provided the jurors with a supplemental questionnaire dealing specifically with the issue of exposure to the political advertisements. And then each party had the opportunity to exercise 10 preemptory strikes, which is well above the number of strikes allowed for by statute, which would be 6 based upon the homicide charges, 1 extra for the alternates, which would be 7. But out of an abundance of caution and in the interest of justice, the court gave each side 10, for which many of those Mr. Brooks chose not to exercise. And then pursuant to state law, the clerk of court chose names to strike by lot. Again, there's nothing on this record before the court to suggest that this jury that we have is anything but fair and impartial. And I take issue with the characterization that they are anything but. They've been diligent, they take notes, they are attentive. They come to this court, as the case law says, there's a presumption that they come to the court without bias, and it's through the jury selection process that the parties and the court ferret out that bias. Many of the jurors who were brought in were struck for cause. Many others were not. But ultimately, we have a fair and impartial jury. As I listen to the litany of issues and arguments and complaints raised by Mr. Brooks, I would note that they are all unsubstantiated, conclusory allegations and assertions without an adequate basis raised in law and fact. There's been several misstatements by Mr. Brooks regarding either the record that's been made, items that's been provided to him, or the basis for the court either sustaining, I should say, or overruling objections, for an example. There's been a mischaracterization of his rights that he claims to have. As I have stated repeatedly, your constitutional rights are not absolute when you're in a criminal trial, meaning your First Amendment right is not unfettered. It is frankly no different why the case law is very clear. You can't yell fire in a crowded theater. No one has a First Amendment right to do that. In a criminal case, the parties have an obligation to follow not only the Constitution and the statutes that are applicable, but to follow criminal procedure, the rules of evidence. That is what circumscribes the rights that a defendant or the state has in a criminal trial. The issues you raise, for example, regarding subject matter jurisdiction are baseless, they're frivolous, and they're not anything this court needs to address further. The fact that you now are asking questions about whether this is admiralty court or a military court or a court of competent jurisdiction is frivolous. This court has jurisdiction over the criminal cases brought before it by the state of Wisconsin. In this particular case, these are allegations that criminal conduct occurred in the city of Waukesha. The city of Waukesha is within the county of Waukesha. This court sits as an elected official in the county of Waukesha to hear these types of cases. That is clear. The only argument or relief that I could discern through the course of those 50 minutes was Mr. Brooks's request that this case be dismissed for lack of subject matter jurisdiction. And as I have just indicated, this court has jurisdiction. It's not been raised. Let me rephrase that. The issue has not even been raised properly. There's never been a written motion. There's never been even an oral motion that would comport with 80201, which requires that the basis for the relief being requested be stated with specificity and be based in law and fact. The vast majority of the points that you raise, sir, are issues that you can raise on appeal. It is true, you have a right to an interlocutory appeal. I would not be the judge to decide any of those issues. So the fact that you complain about what I do, it's noted, the record is going to be very clear, all right? I have a court reporter who's taking down the record of everything that is said and done in this courtroom when we are on the record. And so I don't have to all the time say it's noted for the record because we're on the record. I sometimes do that to hopefully make it clear to you or to note it. I don't always do that, but I'm not required to do that. You raise issues concerning, I guess, plea bargaining. I have never been made aware that you would want to change your plea in this case, and that you're not aware of the state wanting to do that. That is the first time any such issue has been raised, and I see it as a distraction and as simply a statement made by you as part of the litany of things that you are not perhaps pleased with. As far as my conduct in this case, I already addressed those issues. I'm not going to revisit issues related to my familiarity with the father of one of the victims. That was done very early on. I made a very thorough record, and I gave the parties at that point an opportunity to address that after they had ample time to digest that information. While it's true you have a right to seek substitution of judge, it is not unfettered. There was a time limit for that. In fact, it was exercised because a prior judge was assigned to this case, and your attorneys on your behalf exercised that right of substitution. So to say that you have the right to seek recusal at any time would be a misstatement of the law. And even if you think that should be exercised, or there is a valid claim for that, sir, it's not been raised in the proper way before this court. This trial will keep going. I still expect the basic rules of civility and decorum to be followed. That includes, sir, that when there is an objection to a question that you ask, that you wait for the state to indicate their objection and the basis for it. If I need additional information, I will ask for it. If I don't need additional information, I will rule on it. And I do expect that even if you disagree with that ruling, that you will abide by it and that you will move forward. Whether that's asking a new question, rephrasing a question that you've asked, I do ask that you follow that simple rule of decorum, and that's you not interrupt, and then you follow the rules of procedure. As far as the other issues you raised concerning your right to assistance of counsel, the record before this court over the many days that that topic has been raised, even going back to the 2 afternoons of hearings this court held, I will not revisit those. I believe I honored your request to represent yourself as is required by the Constitution of not only the United States of America, but the Constitution of the state of Wisconsin. And that you made a very deliberate choice after being fully advised and aware of all the requirements that I needed to go through under the case law, both case law in the state of Wisconsin and case law from the 7th Circuit Court of Appeals, which not only guides this court, but this court must follow. I agree with the state and would draw your attention to the 2 cases that were cited. United States ex rel. George versus Lane, found at 718 F. 2nd 226, and Retzlaff versus Moran, found at 2022 Westlaw 3045190. I let you put on the record all of those points in order to give you that opportunity to make a full record of the issues that you have believed that you are entitled to raise. But those sovereign arguments regarding written findings of fact, bill of particulars, regarding contracts that you enter into, regarding admiralty court, etc., they're baseless, sir. And this court need not address them further. Now, with that, I know it's 11:30, but I would like to get one more witness on before at least we break for lunch. The jury, of course, has been out for quite some time. So I'll instruct Madam Clerk to bring the jury out.
For the record, Your Honor, you didn't bring up the Higgins-Levine 415 U.S. 533 decision. That was not addressed, and the issues are still not addressed. There's still been no proof to anything that you said, anything that the prosecution has said. It still hasn't been.
Objection is noted, and we will continue. Bring the jury out, please.
There still hasn't been
Mr. Brooks,
any proof.
I've addressed them
There
to the
still
extent
hasn't
that
been
I
any
will.
proof. There still hasn't been any proof. I never once. The comment about me not flinching was when you said that there's 66 years of experience at that table. That's the comment I said that doesn't make me flinch. That was mischaracterized. That should be for the record. There's still been no proof.
Mr. Brooks, please stop. I'm not going to address whether there's verified proof or not of jurisdiction,
Because
whether
it's not.
there's anything along those lines. It is frankly not required under the law. You may disagree with that. You can take that up on appeal, whether that's an. To put that on the record since that was an issue raised by Mr. Brooks previously. Now, I need to get a copy of the jury instructions. They were quite lengthy. The record should reflect that Mr. Brooks was provided with a written copy. It's 107 pages, and the state was provided with a written copy as well. Again, it's all the same 107 pages, and then my written copy is on its way.
I set the value, return the value each document. That's if I'm not muted.
You're not muted.
I also would like to again ask for subject matter jurisdiction and improvement on the record.
Your request is
It
denied.
has yet to be verified. It has yet to be verified.
Your request is noted.
Your Honor,
It's denied without further hearing or consideration.
I was just told that the evidentiary phase is supposed to be closed, how come I haven't been able to present my evidence into the record as I've asked numerous times on the record to be able to do? I've said I have numerous documents that needed to go into the record. Why have they not been permitted to be made evidence? I didn't rest my case, so I don't know why that's being told. And I have yet to be able to offer my exhibits into the record for evidence. How is that so, Your Honor?
Sir, the court did declare the evidentiary phase of this trial closed. I specifically found that you forfeited your right to present any further evidence or testimony when you failed to answer my questions regarding the calling of witnesses. And then I also declared that you forfeited your right to testify. Specifically as it relates to your trial filing, sir, I would note that all evidence in a trial must be proper, it must be probative, it must be relevant, and it must follow all rules of procedure and all rules of evidence. To the extent that you wrote all of those documents, sir, that would be hearsay. And for that reason, I'm denying your request to make them part of the record.
They were not hearsay, Your Honor. I did what you told me to do. You told me, since I was representing myself pro per, that I had to write everything out and present them to the court.
So that's not what I said. You're misquoting me, but in any event, I'm
No, that's
denying
what
your
you said.
request. I
So
said,
you're saying that I have no right to present evidence and to have exhibits as the state's been able to do.
Mr. Brooks,
Are
I'm
you
not
denying
going to
me
have a debate about this
Are you
now.
denying
I
me-
have,
are you-
I gotta
are you
mute him
denying me
once
your
again.
right?
So, Mr. Brooks, I have muted you because I declared the evidentiary phase of this trial closed. You forfeited your right to present further evidence and testimony previously by refusing to answer the court's questions. I will specifically address the filings. Number one, it is not true that I advised him that any filing would become evidence. That is simply false. Number two, filings, I told him if he wanted to present motions, should be written down and should be based in law and fact and request specific relief. I'm well aware that previously he has referenced he would like his filings made exhibits. I've reviewed those filings. There's nothing relevant, nothing probative, or the information contained therein is hearsay. Mr. Brooks would have needed to testify regarding any statements that he, from himself, testimony. He cannot simply put in an affidavit. That's not proper. That's hearsay. And he hasn't asked in any of those filings that he hasn't put forth any exception to the hearsay rule that would allow this court to admit his written filings. I believe without fail they are all irrelevant, not probative, and hearsay, and therefore not admissible. So we're moving on to the discussion of jury instructions. When Mr. Brooks wants to abide by the rules of decorum and civility, I will unmute him. He clearly just took the entire packet of jury instructions and put them, I don't know what's under the table, if it's a garbage can or if he just simply put them under the table, but they are no longer in front of him. I will, however, unmute him so that we can get his feedback regarding jury instructions. It's typically a back and forth. We'll go through them, and I'll ask the parties whether there are any instructions they believe should be included, and we'll have a discussion on that, and then we'll talk about whether any of the instructions that are in here need to be modified in any way, taken out, edited, etc.
Beauty.
All right, you're unmuted now, but you have to not interrupt.
You can't, I'm not trying to interrupt, but how can you deny me the chance to put on the adequate defense by saying nothing that you told me to do can be presented into evidence? So you filed them, you filed everything that I gave to you,
All right,
filed.
Mr. Brooks, I'm
And
going
now
to
all of a
mute you
sudden-
because this is not relevant at this time.
It is.
He's raised tone of voice, he's very animated, he threw the jury instructions on the floor. I understand you're upset, sir. I understand you believe I'm violating your right to present a defense. I've made my rulings. I determine you forfeited your right to testify, which includes the right to present evidence as you would have testified. I closed off your ability to call any other witnesses by finding that you forfeited your right to do so based upon your conduct. I understand you're frustrated. I understand you believe that I'm not without authority to do that. I made specific factual findings. I've referenced the law, and you being upset with the decision is not going to change my mind. He's also taken the headphones off. It's his choice right now whether he participates in a packet of jury instructions and put them, I don't know what's under the table, if it's a garbage can or if he just simply put them under the table, but they are no longer in front of him. I will, however, unmute him so that we can get his feedback regarding jury instructions. It's typically a back and forth. We'll go through them, and I'll ask the parties whether there are any instructions they believe should be included, and we'll have a discussion on that, and then we'll talk about whether any of the instructions that are in here need to be modified in any way, taken out, edited, etc.
Beauty.
All right, you're unmuted now, but but you have to not interrupt.
You can't, I'm not trying to interrupt, but how can you deny me the chance to put on an adequate defense by saying nothing that you told me to do can be presented into evidence? So you filed them, you filed everything that I gave to you,
All right,
filed.
Mr. Brooks, I'm going to mute you because this is not relevant at this time.
It is.
He's raised tone of voice. He's very animated. He threw the jury instructions on the floor. I understand you're upset, sir. I understand you believe I'm violating your right to present a defense. I've made my rulings. I determine you forfeited your right to testify, which includes the right to present evidence as you would have testified. I closed off your ability to call any other witnesses by finding that you forfeited your right to do so based upon your conduct. I understand you're frustrated. I understand you believe that I'm not without authority to do that. I made specific factual findings. I've referenced the law, and you being upset with the decision is not going to change my mind. He's also taken the headphones off. It's his choice right now whether he participates in this jury instruction conference. It is his choice. But if he is going to spout off about things that I've already determined, I will continue to exercise the mute function on the audio equipment. I'll unmute him again, but you are advised, sir, you need to be proper, you need to not interrupt, and you need to stay on task, which is we're discussing jury instructions, not other evidence, not subject matter jurisdiction, not your belief that I told you to file things a certain way. We are now discussing jury instructions. So once again, I'll unmute him to see if he can follow these simple rules.
You need to tell me why I can't present evidence. How can you deny me the fact? How can you deny me my right to present evidence?
All right, I will mute him once again because he wants to continue. And again, I understand he's upset. I understand that. But he has himself to blame for his conduct this morning and the rulings that I've made. All right, so let's go through these jury instructions. First of all, has the state received a copy of the draft?
Yes, Your Honor.
Thank you. Mr. Brooks, do you acknowledge receipt? I believe you did by acknowledging it previously, but do you acknowledge receipt of the draft of the final jury instructions?
I didn't acknowledge nothing, and I don't acknowledge anything now. I have not received anything.
I would ask the bailiff to pick up the documents from the floor and put them in front of him.
And I'm not presenting it to nothing I don't give my consent to. You can't deny me the right to put on a defense. How can you tell me when I just stated
I'm going to
3
mute
or
him
4
once
times?
again because, again, I understand he's upset. If the bailiff could confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior rulings regarding his forfeiture by conduct of his right to present further evidence on his behalf. I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amendment from the amended information on count 70. No, I don't want to do that.
Oh, you don't? I changed,
Hold on. 76, the 76 count, just want to make, it says near Frame Park, so it is in there, but that was just one question I had. All right. So, state have any requests as it relates to the jury instructions?
I'm just going through each one. I'm on page 50 of 107. Everything's looking great so far.
Okay. Fair enough, there's 107 pages. I certainly can give the parties some time to continue to read through them.
I put 325, 141, and 172 at the end because I wasn't sure.
Yeah, Mr. Brooks is requesting to go back to his cell. At this point, I'm going to deny that request. He can remain in the other courtroom. I know he's muted, but I can certainly hear him from this side. He appears to be yelling at the top of his lungs. I can't decipher what he's yelling. I'll advise Mr. Brooks, without a specific waiver of his right to be present, even if it's from the remote courtroom, he's going to remain in that courtroom. And that would require him to have a colloquy with me. I know I'd ask that it be put in writing, but I'll also give you this opportunity to verbally advise the court and make your request. Do you have any requests as it relates to the jury instructions, sir? I would note he put 2 boxes right in front of where he's seated, so I can't presently see his face. I see his jacket is off because I can see the outline of his arms, and I can see the jacket on the back of this chair. He is unmuted. I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as it relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table so we can
Yes, I think that's fair. I'm going to advise the bailiff to remove the box so I can see Mr. Brooks. I don't know what he's doing behind there. He has quieted down. I haven't heard him in a while. If you could move the second one because it can interfere with the microphone as well. And the third. Mr. Brooks, I'm going to ask you for a third time. Do you have any requests as it relates to the jury instructions? Any requests for instructions that aren't included that you believe should be included? Any edits or deletions from the packet that has been provided to you?
Hey, why do you tell them to move my box?
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or otherwise?
Hey man, you don't gotta talk to me like that.
Do you have any requests
First of all,
related
what?
to the jury instructions, sir?
Man, yeah, I got requests. It ain't like they gonna be honored though, cause
As it relates to the jury instructions, sir, what are your...
I heard what the hell you said, man.
Well, Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Mr. Brooks, do you have any requests?
I'm tired of my rights being trampled on here too. I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
Ain't nobody understand why I'm frustrated. How you gonna sit up here and make decisions based on what you think I said when I didn't get consent for you to do any such thing?
Sir, I understand you may be upset, and I really do,
No, you
but
don't
I've made my
understand nothing.
determinations.
You don't understand nothing. You don't understand anything, Your Honor. You don't.
I'm going to mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him 5 opportunities. Mr. Brooks, do you have any requests as it relates to the jury instructions. I'll unmute you for that answer.
I can't hear everything you're saying.
Mr. Brooks, I know the audio's turned up. I believe you can hear me. You've chosen not to put the headphones on. That's your choice. My final question to you, do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you said.
Then you should put the headphones
What about that,
on.
don't you understand? What about that, don't you understand? If you see headphones, you can see everything, you can see boxes, but then you see headphones.
Have you
No,
asked
no.
for headphones to be provided, sir?
I shouldn't have to ask for them. I didn't ask for my boxes to be moved.
I believe they took them away previously because you were so agitated, they were perhaps afraid you might break
Yeah,
them.
I'm still agitated. I ain't gonna stop being agitated. That ain't gonna stop. You sit up here and do everything you doing and think God don't see what you doing? You ought to be ashamed of yourself.
Mr. Brooks, do you have any requests as it relates to the jury
Yeah,
instructions?
I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is
Yeah, I
it?
got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little image of sir. Now it's all this sir and all this. I'm gonna get where I'm going. Try to put on this little act like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
You've been being disrespectful. You've been being disrespectful.
I need to know what your position is regarding the jury instructions. And I need to know it now.
What you mean? Who you talking to?
I'm talking to you. I need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumpings when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
It's not double jeopardy. Your objection is
It
noted.
double
It's
jeopardy.
overruled.
It is double jeopardy. How you gonna charge me with the same charge that I'm already charged with? You can't do that. The Fifth Amendment says that you can't place somebody in jeopardy of life and limb. Twice. I'm already charged with the same count in Milwaukee. For the same case. It's the same bail jumping charge. So how am I charged with that here?
Sir, I'm not going to provide a legal explanation other than to say I've reviewed that. Your objection is noted, but the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. Under the law, if two charges are identical in nature, you cannot place me in jeopardy of life and limb twice. You can't do that.
What's your next?
The same case number.
What's your next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out? You always want me to not interrupt you, but you always find a way to talk over me.
I understand your position. I'm saying it's overruled.
You always want respect, but don't want to give it. I'm charged with the same bail jumping charge here that I've already been charged with. That is double jeopardy. You can't charge me for the same exact bail jumping that I'm already charged with, that I was charged with before this even came about.
Sir, the bail jumping charges in Waukesha County are based upon your violating your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others.
Okay.
That's the distinction.
again, there is no distinction. It's the same charge.
It's the same offense. It doesn't mean it's the same factual basis, sir.
He is not
It
charged
is.
with bail jumping with the data violation of November 21 in Milwaukee County anywhere. Further, the double jeopardy prohibition would prevent him from being convicted twice, not charged twice.
All right, so we've addressed that, sir. What other requests do you have as it relates to the jury instructions?
I want to know why I'm even charged twice with the same thing. You can't charge me in pursuant to a case in Milwaukee that I'm already charged with bail jumping for. I'm already charged with bail jumping for that already. So you can't essentially say, oh, well, because you were already on bail, we're gonna charge you.
It's a different data violation, sir. The conduct for the bail jumping is related to the allegation that you committed a new crime in Waukesha County while out on bond from the Milwaukee County case.
Yeah, but I'm referring to the first bail jumping count. The first. I'm not referring to both of them. I'm referring to one of them.
My understanding,
That's one
sir, is there's different dates of violations as it relates to that. So I've noted your objection now repeatedly. I understand it. Your request to, I guess, dismiss the bail jumping counts are denied.
I didn't say nothing about counts. I said one.
Whether it's one count or both, it's denied.
Am I not being understood? You can't charge me with the same charge twice. You can't.
It's two separate cases, sir. There's two.
Is it that 971.23? Is it that the statute that refers to the double?
All right, sir, I'm not going to have an argument. This isn't fruitful. I understand what you're saying. You're saying there shouldn't be two counts of bail jumping. You believe it's double jeopardy. I disagree with that. They're separate.
I'm already charged with it, though.
This is a circular argument, sir. It doesn't change the fact that, from my perspective, the two bail jumping counts are going to proceed forward. There's been sufficient evidence presented to warrant the jury being instructed.
They can't.
What other requests do you have,
You're not
sir?
gonna talk over me. Don't talk over me. Just like you don't want me to talk over you. Just like you don't want me to talk over you. Just like you don't want
Mr.
me
Brooks,
to
what other requests do you have?
And I just asked you not to talk over me. You've been making your record the whole time you've been over there. You had me muted. I didn't see no requests over there. I didn't write nothing to go over there. I let you do what you was doing. No matter how egregious and biased it is, I'll let you do what you was doing. Because we both know that what you're doing is not right.
Mr. Brooks, I'm going to refocus your attention to the jury instructions. All of your objections are noted. I understand that. If you can't answer my question, I'm going to move on.
You can't. I haven't given you consent. Just like
All right, I'm going to mute him once again. He refuses to answer simple questions regarding if he has any requests. He just made an argument regarding the bail jumping, so clearly he has an understanding about the law as it relates to that. It may be a misunderstanding about the law and double jeopardy, but he made an argument. I've denied it. I'd like to know if he has any other requests. If he can stay on topic, I'll I will unmute him again, and he can tell me the list, just like the state went through a list. I need to get through their list. I'm asking you to list out all your requests, and then I will take each one up in turn. So here is your opportunity to give me your other requests, not debate with me about prior rulings. Go ahead, Mr. Brooks.
Don't sit up here and try to play no game talking about you giving somebody an opportunity because you haven't gave me an opportunity to properly defend myself and put stuff into evidence, which I've asked you repeatedly to do before we even got to the trial. You told me we wasn't in the evidentiary phase.
Mr. Brooks, do you have any other requests as it relates to the jury instructions? This is probably the 10th or so time I've asked you this question.
No, no, it's not. No, it's not. So please stop being incorrect, Your Honor. Please stop.
Do you have
stop.
any additional requests as it relates to the jury instructions?
Yeah.
Oh.
That first count 74 bail jumping needs to be dismissed. You can't charge me with two things. You can't charge me with the same charge twice.
All right, I've made a note of that. What's the next issue?
Either one county gonna charge me with it or y'all, but it can't be both. It's the same, it's pursuant to the same exact thing that I was on bail for. The same exact thing, the same exact case. So why are we giving the jury instructions on two cases from another county?
I've made a
And I'm
note of
already
that.
charged
What
with
other
bail jumping in one
what
of
other
them and
requests do you
charged with
have?
bail jumping here. Man, this is ridiculous. So I'm not even able to adequately defend myself, present evidence, do anything, because everything I say is gonna be found a reason for it not to be valid. What are we doing here, Your Honor? What is the
Mr.
point of me being
Brooks.
here for? Why should I be here when the
I've
right
made a
already
note of your
involved?
request as to count 74. Do you have any other requests as it relates to the jury instructions?
Why are we even having jury instructions? Why do I have to even sit here in this courtroom at this point? Because everything you've been doing without my consent anyway, so you're gonna find a way to do this without my consent. So why do I need to be here for?
Your objection for lack of consent is noted for the record.
Okay, yeah.
Any other requests, sir?
You talk a good game. You talk a good game to save yourself enough space. But everything I bring up has no merit in your court. None.
All right, I've asked him many times. I've advised him, and I'll advise him once again. If he fails to answer the question, I'm moving on. Do you have any other requests as it relates to the jury instructions, sir?
You can't move on because I haven't given you consent to it.
All right, he did not answer. So I'm muting him again. The only request that he has made as it relates to the jury instructions, as he pounded his fist once again, raised his voice. I understand, I really do, that he's upset with my decision to cut off his ability to present a defense, but that decision was made based on his conduct and his conduct alone, as I've outlined already on the record. So the only request that he made was as it relates to the bail jumping counts. I'm denying those requests, whether it be to dismiss one count or to dismiss both on double jeopardy, or to just not instruct the jury. However way I interpret it, I'm denying that. All right, let me go through the state's.
Your Honor, can I add one more?
Sure.
I'm sorry. 154, summary of evidence. I believe we had a map, actually two maps that summarize the, we had three maps. I think the one was summarized his route, the path that he took. The other one summarized the victims who were struck in the specific locations. And the other one summarized the positions of the law enforcement officers at the various intersections and throughout the parade route.
I'll make a note of that. I don't believe I saw the jury view instruction either. I mean, that was given to them at the time. I don't know that it needs to be reread, but I think we need to consider that as well. And that was my version of 152. All right, so let me go through the list from the state. Turning to page 61. So I've considered the request by the state. I am going to rely on what information they put in the charging document. I'm going to deny the request to include the specific case numbers. There's evidence, of course, that was received regarding the two separate cases out of Milwaukee County that form the basis for both of the bail jumping counts. It will be up to the jury to review the evidence and make a determination. As to the verdict forms, though, that were referenced previously, at least the description of them in the jury instructions, that obviously the third count of bail jumping is incorrect. That needs to be battery, and that change will be made. I'm also having Madam Clerk include all of the numbers for the jury instructions when they go back, so it's very clear. Some of them did not have them on, just frankly from prior cases that she and I have worked on, but in this case I want to be very clear with all of the numbers. So I think I've addressed the first two bullet points. As far as the motive instruction as a standalone, I believe that is appropriate, and I'll instruct Madam Clerk to include that. As far as where it goes, I'm going to just, any instructions that we add should just be in the numerical order, unless there's a other request that's made. Then the state also made a request as it relates to jury instruction 70, which is found on page 65. So as it relates to this, the state is asking that I simply instruct the jury based on the pattern instruction and not include that second paragraph. I had previously advised the jury with another paragraph that I was contemplating including, even if I took out that big paragraph that just said, at times Mr. Brooks has appeared from another courtroom. This must not influence your verdict in any manner. What's the state's position on including that but taking out the paragraph you request to be taken out?
That's fine.
Mr. Brooks, do you have any position on that? Which is, so jury instruction 70 has to do with the defendant proceeding pro se. The pattern instruction would be basically the first paragraph. I need the bailiffs to move the boxes away from his face. I need to be able to see him. He can keep them on the table, but they need to be moved off to the side. And if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials related to jury instructions, he should take those out now. Otherwise, they need to be moved away from the microphones and away from blocking his face.
I'm not putting them there. I'm not putting them there to thank you. I'm putting them there for a reason. I'm going to do with her DNA.
Mr. Brooks, do you have any position on the verbiage of jury instruction 70 on page 65?
Don't ask me no question. Are you my accuser? Are you my accuser, Your Honor?
All right, he's choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this. I agree with the state. I don't need to highlight with that second paragraph. I will take that out, but I will include in the paragraph that reads, at times, comma, Mr. Brooks has appeared from another courtroom, period. This must not influence your verdict in any manner. All right, then I want to talk briefly about the jury view. I did provide the parties with a proposed instruction. Before I get to that though, Mr. Brooks, I have been thinking about your request yesterday. And I know I indicated to you that I would require you to be there. I've rethought that. I've had the overnight to really think about it. And if that is your decision to not be present for that, what I would say is this. I want you to be advised that you have a right to be at that jury view. Did you hear me say that?
Yeah, I mean, you pretty much told me yesterday about, everything that was going on. I didn't agree to or consent to it being, well, I was still confused about why did there even need to be a jury view. That was my whole thing. I don't see the relevancy of it, and I also didn't agree with or consent to having to be part of something that I don't see as relevant.
I appreciate you making a record of that, but did you hear what I said, that you have a right to be present for it? I've ruled that let me back up. There's been a request from the state to have the jury look at the vehicle that was recovered by the police and, of course, is alleged to be the vehicle that was driven through the parade. Did you hear me advise you of that?
Yes, I heard.
All right, so that motion was addressed previously, and I granted the request for that jury view. Did you hear me say that?
I'm informed.
All right, thank you. So with that, you have a right to be present at that jury view. Did you hear me say that?
I'm informed.
And I would like you to be there. I believe it is a piece of evidence. That's why I've drafted jury instruction 152 the way that I did. Did you hear me say that?
I'm informed.
So my question to you then this morning is, do you want to be present at the jury view of the vehicle?
I don't see the reason why I would need to be present.
Well, that's my question to you, though, is do you want to be present for it? You are the accused in this case. You're the person who the state has alleged committed these acts. The jury view will be to view a piece of evidence that frankly can't come into the courtroom due to its size, and the jury's going to be shown that. So do you want to be present at that?
For the record, I'm not a person, I'm a human being. And no, I do not consent to or agree to being present at a jury view.
All right, then I'm going to honor his request, but what I am going to do, though, is as part of that process in any event, because it's being done in a secure location, is I have ordered that I want to make a record of what's being done, and I want a visual record of what is being done. And so this jury view is going to take place in the Sally Port of the jail, and precautions are being taken so that the jurors do not know where it's at. It'll look like a garage, right? Anything that says jail within the Sally Port is being covered up. That will be verified before anyone is taken in there. They will be transported to there. I'm not sure if they'll walk or drive because it's very close. But then the sheriff's department, because as the court official, I'm in charge of keeping the record, not keeping the record, I'm in charge of making the record. It's the better way to say it. And I want to make sure that there's a record of what is done for this trial and certainly for any appellate purposes if need be. The sheriff's department, the sheriff's department is obviously charged with the security and safety of a courtroom, including the jurors. And so I have asked the sheriff's department to record. And so there is a camera that will be on a tripod that will record what's there before anyone gets there. I've instructed them to take that camera to walk around the vehicle and while it's recording to put it back on the tripod. And before the jurors and the court are brought in, once we are brought in, it will also be recorded, and that contemporaneous recording, so that will be as we will walk around the vehicle one time. That will be recorded, and then both of those recordings are going to be made part of the record. Because the second recording is for the record and has the jurors, at this point I'm going to seal it so that at least until the conclusion of the case, given the order that I have regarding the what's referenced as an anonymous or numbered jury, so that will be sealed. But what will be released to the public or be made part of the public record, and so therefore any media request, would be that recording that just shows the vehicle without the jurors in it and without the court. So, and then I plan on also bringing that back to the courtroom while the sheriff's department's going to bring it back, and then we'll show it to you at that time.
I have a question though.
Go ahead.
If I have a right to be present, then I have a right to not be present. How can this take place if I don't agree or consent to being present? How can it even still take place without me?
It will take place, sir. I'm just going to honor your request not to be there.
I'm asking a question though. How can it take place without my consent or agreement?
If you don't, it's going to take place. That's how I'm going to answer that, sir. So you not going there is not going to prevent it from happening.
My Lord,
But you can forfeit your right or to be there by your conduct. And by your conduct, by not answering my question, by saying I don't want to be there and I don't consent to it, you will be forfeiting your right to be present and essentially waiving that.
Doesn't I have to sign something for it to be waived?
I don't think so in this case.
Well, yesterday you said something about
I know I said that, and I've had some time to think about that further, and I don't believe I need to take a full waiver with you signing anything or even agreeing to the waiver.
So why did I have to do that for when my
I'm not going to answer those questions because that would be for me to give you an explanation of the law.
No.
I'm just going to tell you that I'm not going to require a written waiver from you in order to honor your request to not be at or even if I phrase it, your lack of consent to the jury view.
And is that lawful law? Because
sir, I'm not going to go through all the law that applies to that. This is my ruling. If you disagree with it and ultimately there is a conviction, you can raise that on appeal. But your lack of consent is not going to stop the jury view. It's going to happen. It's a piece of evidence that I cannot physically fit in this courtroom. It's too big. There's no way to get it in.
Okay, I'm informed of that, but at the same time, if I haven't signed any waiver, how could it be lawful? I haven't given consent or agreement to a jury view. I haven't waived any right. When the whole issue was brought up, on the record yesterday, my first thing that I said was, I don't see the relevancy of why there should even be a jury view. And that was the whole issue. And yesterday I was told about I don't know how you say it, the colloquy or however you say it. I don't know how to pronounce it.
I know what I said, and I'm telling you I had time to reflect. That was my initial reaction to your statement yesterday, but I've thought about it some more and I'm changing my mind. I don't believe I need to take a full waiver with a colloquy with you and anything in writing. I'm advising you, you have the absolute right to be there. But I'm also advising you that if you choose not to be there, I will honor that request. And I'm not going to force you. I'm not going to direct the sheriff's department to, use any type of force, if you will, or require you or get you there without your consent. You either cooperate with that process or you don't.
The way I interpret the law, though, Your Honor, which the law is designed to be interpreted by the people. The way I interpret that is I have the right or essentially to be there or not to be there, and it still has to be an agreement or consent. That's how I interpret the law.
My ruling on that, sir, is I disagree with you. You do not need to provide consent for the jury view to happen. Your objection is noted for the record. I'll make a specific finding today that it is relevant to these proceedings, to this trial. There is an allegation that you drove through the Waukesha Christmas Parade on November 21 of 2021, driving a red Ford Escape, killing 6 and injuring dozens more. The relevance is that there is, in addition to the charges, there's an enhancer that has been charged as it relates to the intentional homicide charges and the first-degree recklessly endangering safety, that you committed those acts while using a dangerous weapon. I would direct your attention to the meaning of a dangerous weapon, that the legal definition that was provided to the jurors in the preliminary jury instructions, and that the jury view is related to the evidence that the state is presenting regarding the charges, and specifically the instrumentality that they allege is the dangerous weapon. So there's clear relevance of this vehicle and has evidentiary value. Again, your objection is noted for the record, but I will and am permitting the jury view of the vehicle. With that, I'm going to move on to the jury instruction.
I don't agree or consent to that, Your Honor.
I understand your objection is well noted for the record. I need to keep going though on the pattern and jury.
I'm informed that you need to keep going. I'm not trying to stop you from continuing to go. I'm merely stating for the record that there are things I do not understand how they're being permitted versus the Constitution. I mean, I'm sure you're aware under Article 6, Chapter 2 about the Supremacy Clause that the Constitution is the supreme law of the land. So how can we disregard?
Mr. Brooks, I'm not disregarding the Constitution. Here's the thing, I've made my ruling, okay? Once I've made a ruling, I do expect that even if you disagree with it, you will not continue to argue it.
It's not
that
arguing.
We will continue on with the next topic.
I'm seeking to understand, Your Honor. It's not an argument.
Mr. Brooks, I'm not going to explain further other than what I have done, my ruling. My ruling stands. Now, I'm going to move on to the jury instruction. I gave the parties 2 documents.
May I respectfully reject that ruling and take exception to that ruling?
Your objection is noted. I'm
For the
moving
record,
on to
may I
jury.
request a legal or factual basis for your
Mr.
ruling,
Brooks,
Your
please
Honor?
don't interrupt me, okay? I give you an opportunity to raise your objections and to make your legal arguments,
raising
and then I make a
objection now.
ruling, and then you start in on something else. You need to give me your argument all at once. For you to interrupt me afterward is disruptive to me.
It's not disruptive.
And it's interrupting and it's disruptive.
It is definitely not disruptive.
Well, that's my view of things, sir, and what I'm putting on the record is that it does disrupt what I'm doing and the flow of what I'm doing, and needing to move on, having to interrupt what I'm doing so that I can address that once again. Please, please. I know you may not always agree with my rulings, but I'd ask that you show the courtesy and decorum that is expected of everyone, and once I make a ruling, we're going to move on. You don't need to keep objecting because your objection's already been noted for the record. I'm going to continue. We're going to look at jury instruction 152.
Well,
I gave the parties 2 documents yesterday. One was the pattern instruction, which I've modified, and then one is the draft of, Mr. Brooks, please stop. You're continuing to talk over me.
Because
you're interrupting.
You said I have the right to object, and you didn't let me even get to the objection.
I did, sir.
No, you didn't. I was right in the middle of it.
Your objection comes before the ruling, not after. Once I make a ruling, we're moving on.
You made a ruling before we even finished the conversation, Your Honor. With all due respect,
Brooks,
before we
stop.
even finished.
That's not true. Okay?
You said
I'm
going to make a ruling. As soon as you even started in about
Mr. Brooks, I'm not
having
going
the
to
time
spend
to think.
hours on end making a ruling about a jury view on something I've already decided. All right? So please, I'm asking you to stop. Stop interrupting me.
You can't,
and please listen.
Just disregard the United States Constitution, which has a
I
supremacy
absolutely
clause.
am not disregarding the
You
United
are.
States Constitution
You're not
or the
honoring your oath
Constitution
of
of
office.
the state
Your
of
Honor,
Wisconsin.
are you not a public servant?
Okay, Mr. Brooks, you're starting to cross the line. You've already crossed it, but I want to keep going. I want
didn't
you in
cross
this
any
courtroom.
line.
But if you keep interrupting me and putting you on notice that you run the risk of being.
Yeah, so basically, hello Joe, good to see you. So in this situation, the officer can only do something if he tries to attack her, things of that nature. But I will say she was very patient, and yeah, there are people that disagree how she handled the situation. Now, there's theories that if she were to not acted the way she acted, there could have been reasonable doubt that could have been raised for a mistrial. So she wanted to avoid a mistrial as much as possible when he was defending himself. So she wanted to, that's why she did how she handled it, to show that if there was like an appeal or a mistrial situation, that she treated him perfectly fine. So that wouldn't be raised, in my opinion. Definitely contempt of behavior. Absolutely. I would have shoved that water bottle up his eos if he kept going. My foot was next. Yeah. Yeah, shove the Timu fish market boxes up there. I roll that too. Yeah, facts, Joe. So, but definitely, it was this. He was a pain in the arse in the eos. Definitely. Absolutely. Yeah, more than tolerant. Yeah, definitely a saint indeed. And this is certainly comedic scenes in a way, like another trial. Oh, couple of days ago, like last week, one of the people that have seen me in the trial chats before randomly found the channel and was talking with Darrell Brooks, and then we're like, we need to do some more reactions to this one. And yeah, because this one is another. He's annoying, but it's also comedic value to it also. And y'all could see just how ridiculous some people are, and learn more about the court system. Ab says, she treated him really good. I love her in general as a judge. I've seen her before this. She's very polite. Yeah, she's very polite, and I think that, as I said, she even helped him a little bit. As I said, it was all, especially during the closing, there was this part where she was reading these documents when jury was about to go and do deliberations, and she was very detailed, said a lot of information. Some people in the audience in the chat were very irritated, but the reason why she did it the way she did it was so they can't raise the mistrial thing. Again, the whole thing, it's the art of how you present yourself. A lot of times you're selling yourself, not what you're saying, and so you could clearly see the way he acts and the way she acted. So anytime there is an appeal or she can't say he was mistreated, that is why they go in very detail with letter to letter why she also read a lot of information out. Anna said, yeah, Joe, and Anna, very well said, Anna. And Joe, yeah, absolutely, Joe, because his rampage upon the innocent is really horrid. And he had political stuff and in his social media, and he seemed, in my opinion, very prejudiced from what information they showed. And he had a lot of hate in him. And he did not express, he could have anger, he could have hate, but he could express it in a different way than this. There's other more productive things he could have done with his life than doing this. I mean, he could have done some push-ups or go do a run. He could have been like a rapper or something. He didn't have to go and murder innocent people. And then he's also a sex offender too. And he blames the girl for saying she was 18, but that's not how reality works. It's like you got to take personal accountability. I will say he acts like a 2-year-old or a kindergartner, and I think he never grew up in his mind. And when you have a combination of those emotions and not being mature and all these different things, in a sense where he is, being immature is okay. There's nothing wrong with that, as long as it's not done like what he did. This guy just is not really all there. And Anna says a good point where he shouldn't have been allowed to defend himself. Who declared him mentally competent is insane. Yeah, and Mary Toodles said earlier about that, how is he seen as mentally competent? And I do not know enough information at the moment about how the proceedings about that, how it went. But it's absolutely that you can raise, like, was he needed medication? Like, what was his problem? Because he certainly made a clown of himself. He certainly did. Very good point. And it's so disrespectful to the victims in this case. These poor people were Dalia killed needlessly, and he's treating this like a 4-ring circus. Yeah, it's the complete Circus Soleil. He is the clown. He is on the tightrope. He is all over the place making his own spectacle, especially out of the victims in these families. Dude had zero remorse is very true. And now towards the end, during his closing, he was talking about he believes in Jesus Christ. And he would bring the Bible out. And you see, only God knows if he saw it or not. But I do not really think, I think he uses God's manipulation. For instance, a previous clip that we saw, he was talking about how, how dare God sees what she's doing. Really? He's using the religion as like a scapegoat, as a way as a manipulation. Oh yeah, Anna, you would definitely. That is true. I would have no patience with him. I couldn't be a judge here. Yes, yes, and he, yeah, this person will test the nerves of even the most patient. So she had, as I said, people are sending her gifts and vacation brochures and trying to get her some wine and stuff, but she was like she couldn't accept the gifts. Doesn't want to see the reason here. Exactly. And now there's people in real life that are like this, like Brooks, and it's like a note to self to be watchful of people that will never take personal accountability, and they will completely be enslaved by their own emotions. He crossed all the lines. He knows his deepest part of the consciousness, his actions were straight up abhorrent. Some people have theories that why that maybe he felt a subconscious guilt by what he did and that's why he acted this way, but and he didn't want to get out. Those are theories I've heard, but I don't know if that's really true. This is people on the internet talking. And Becky says yes, he was have a brain Walshy and minute going through competency at the minute. How did Brooks not go through that before he did? At the minute, I'm repeating myself. Well, yeah, exactly. And there is a scene where he was going through the crowd and he was looking back and laughing. And he was angry, as I said, angry at his girlfriend probably. And as I said, in the moment of the impulsive emotion, people like him are very impulsive. In the impulsive emotion, his anger is a way to control. And he was controlled by his anger. And he was just in that fleeting moment. And he thought that he got it. And he fired his own defense. And I do think that in recent times, he was strapped to a chair and a mask on his face. But when he was in the warehouse, he was more respectful. But yeah, he certainly, his defense agreed to not let certain things out. Because he opened the door for other things to be brought up. He opened the door when he was talking about his SUV. And he is absolutely blaming the judge and everybody else, but his defense agreed not to talk about the SUV in the background, but he did. And he'll talk about maritime law, but there's no maritime law here, because that's to do with the sea. He's really ignorant. And I said he's crazy like a fox. He knows what he's doing and pushing it on purpose. Yeah. He's conscious enough and intelligent enough like a fox, but he does not feel the empathy, compassion, remorse for his behavior. He doesn't really care about the outcome. Very well said, Anna. Absolutely. And Darrell is deaf, competent. Sometimes I wonder how the hell was Taylor Schwab Business deemed competent. Oh yeah, that one. She was extremely, in my opinion, vile and evil, like Brooks. And I think that she definitely got what she deserved too by being locked up, because she wanted to put everyone in the suitcase, put people in the suitcase. Yeah. And yeah, exactly. Yes, he needs a Lori Daybell zapper. And maybe because people like Darrell Brooks, maybe because of situations like that, they got the zapper because people like him. Dodger says he thinks he is smart, but arguing like an idiot. Kid. Yeah, and you see, putting up the boxes is a childish thing. And he's very confident. He's very secure. But the problem is, he doesn't have a heart, though. He's not a good person. So he wouldn't be a reliable person to have around because he doesn't have the compassion or empathy. Like, if he could have both at the same time, be intelligent, that would be good. But he doesn't have the intelligence or the empathy, and he's impulsive, like a snake's impulsive. I'll even say I love my cats, and cats are impulsive too, where they'll just bite you sometimes because it's an impulse. But animals are cute. But this is not cute what he's doing. He's gross. Makes me scared. And Joe said he alleged and tried to escape the fact that insanity plea is invalid in this case. Just straight vindictive and evil actions. Yeah, and I think that he was evil, and he shouldn't be. He was not insane, definitely not insane. But insane in the sense that he should not have been defending himself. But it's good in a way defending himself because he buried his own self deep. But I definitely think that he has screws loose, and his actions are very evil, conniving. And I am surprised, as Anna mentioned, that they allowed him to defend himself, considering how unstable he is at the same time. So, especially for the victims, I could see that. But they gave him a shovel, and they allowed him to dig his own grave. Yes, he has a Robert Tellis forehead. Absolutely. Robert Tellis went on the stand, and he was defending himself, and the prosecution swept the floor with him, mopped the floor with him, because it was in his house, all the evidence that was incriminating, and it was him with the hat on, and he took a shoe off in court, and he was saying about how he feels bad about his height, so he likes to wear boosters in his shoes. And he was talking about how he was at the gym with his, and then he wasn't even at the scene, but the prosecution's like, why is this stuff in there? And that he was saying he was framed. But yeah, Tellis' forehead, definitely. I've had nightmares about Tellis before. Like, it was like, scared. He definitely has a Temu forehead, definitely. And then we got Darrell Brooks here with his egg head and his hairline. Definitely, that's another Temu situation. And his mask, good lord. His mask is another thing to add to the cringe. Tellis' prosecution was like Jody Arias, prosecutor, one iconic, nailed it, no crumbs left. Yes, absolutely. Dodger says he is a little bit better of an attorney than Amber Heard's counsel. Yes, you could say that. Elaine was comedy gold, and I will say he's good at arguing. He is good at, but the things he's arguing about are very cringe. Like, the stuff and the intelligence behind it is very stupid, what he's saying. But he does argue a lot. In Amber Heard's defense, or Rottenborn and Elaine, cringe, right? So, yeah, his slightly better than Heard's counsel, and Heard's counsel did not advise her to be more respectful. At the same time with him, he was very disrespectful in the court, insanely disrespectful, and this is causing a situation that will turn everybody off. Yeah, Anna says, should have had one of those 7-year-old grouchy judges. Yeah, definitely. They would have gotten him in line. Absolutely. Joe said, yes, insane actions. He decided to put of his own free will and harbored discriminatory hatred against people and had no connection with. Yeah. And he did not build a relationship or connection with other people. And he only turned people off. Hamper turd just sucks crook D, literally. Yes. Male judge old. Yes. I see what you're saying. Yeah, they would have put the Womack on him, definitely. They would have gotten that gavel and go bam. That is true, Abby. That is true. Judge Simpson wouldn't have put up with his... Yes, definitely. All right. And, for instance, let's see this.
Forfeiting your right to be present in this courtroom and continuing in the next courtroom so that I can effectively and without interruption continue with the proceedings this morning.
So again, you're holding me in contempt.
All right. Jury instruction 152, as the state had an opportunity to review it.
Is that a judicial determination that I'm being held in contempt?
And I agree generally with the court's proposed instruction. I did submit kind of a counter-proposed instruction following much of the language that you had in your version, Your Honor. I just think it's maybe better to refer to this area as a garage instead of a sally port, I don't know that anybody knows what a Sally Port is unless they work in this industry. And instead of referring it as being in the Waukesha County Jail, I just suggested a garage attached to the Waukesha County Courthouse. I think that is factually accurate and would dispel any concerns about anybody being in custody or reference to a jail setting. I did email my proposed instruction to your clerk and I e-filed it, but I admittedly just did that a few minutes ago. So that's why I emailed it to the clerk, because it's probably not in your queue yet.
All right, why don't we print that off so that Mr. Brooks can review that as well.
Since to being called that name, what do I need to be reviewing?
The state has submitted an alternate proposal for instruction 152.
And that's referring to this quote-unquote jury view?
Yes. Thank you.
I accept for value in return for value this document. Now, I'd like the record to reflect I still haven't received my original copies of my filings here this morning with the timestamp.
Let me know when you've had an opportunity to review it if you so choose.
I just stated for the record, I accept for value in return for value document.
Do you have any position on this state's proposal?
I'm still trying to understand the whole process.
Mr. Brooks, my question to you is, do you have any position on the state's proposed jury instruction? Otherwise, I'm going to rule on their request.
You're going to rule on the request anyway. I got a lot of questions that don't get answered.
I have to rule on the request, sir. It's been a proposal filed with the court.
You haven't ruled on subject matter jurisdiction yet.
Yes, I have.
No, you haven't.
In any event, do you have a position on the jury view, sir?
Yeah, what about subject matter jurisdiction?
One last time, Mr. Brooks, do you have a position on
Can
the
I
state's
go over the
proposed-
document, please? Can I do that, Your Honor? Respectfully
sorry?
for the record, may I do that? You seem like the same thing that was there yesterday.
It's not. There are some changes.
What changes? 'Cause
Reference
it's
to
the same.
the-
It's the same document. That was
Reference to
accepted for value in
the-
return for value yesterday. The same document.
It's not the same. The changes were put on the record verbally by the state. It's taking out reference to Sallyport of the Waukesha County Jail, referring to it simply as a garage attached to the Waukesha County Courthouse. Those would be in the first two paragraphs. I believe the rest is the same.
So it was a couple words changed.
That's my understanding.
So it's the same document.
Let me know when you're finished reviewing it, and
I
I'll have a
don't
question.
have to review the same document that was reviewed yesterday, accepted for value in return for value yesterday.
All right, then let me ask you this, sir. Do you have a position on the proposed instruction from the state?
It's essentially the same document. What was the significance of the change? What's the significance? Garage, Sallyport. What is the relevancy of what it's called?
State want to put on the record again the basis for the changes you made.
Your Honor, to my way of thinking, it is beneficial to the defendant. It removes any reference to a Sallyport, which some may recognize as being part of the Waukesha County Jail. It removes reference to the jail itself. And then in the second sentence, the pattern instruction was worded, and the court followed it. You will be taken to the Sallyport in the custody of the jury bailiffs. I just thought it was better to change that. You will be taken to the garage by the jury bailiffs. Again, removing the use of the word custody is it's factually true, but it's really irrelevant. Just to be cautious, Your Honor.
With that, sir, do you have any?
I don't
Position.
fundamentally understand that. I think everyone's well aware that I'm in custody, so how does the wording change what's already known? Everybody knows that I'm housed in the Waukesha County Jail. How does the wording change what's already known? It's reported on every single day, as it has been since the beginning of trial and even before that. So I don't think anyone's not privy to the knowledge of where I'm housed and that I'm in custody. How does changing the wording change what's already known?
Thank you. From my perspective, of course, when I drafted this yesterday, factually, what I put in there would be accurate because that's where the jury view is going to take place. I think changing the verbiage so that it says a garage attached to the Waukesha County Courthouse takes away any possibility that other law enforcement is condoning what is happening or somehow related to the case. It is true the location was selected due to your custodial status and being able to secure the area for the court, for you, for the jurors, etc. But it's also a controlled environment, I think, a good thing for purposes of the jury view. And so I am going to adopt the draft that was submitted by the state. It still is factually accurate. And from my perspective, again, the importance of this instruction is to tell them what is and what is not evidence, and to instruct them and to not talk during this time. They can't discuss what they see during this time. This instruction will be read while we are still in the courtroom prior to the parties and the court going to the Sally Port for that viewing, and I've already discussed how it will be contemporaneously recorded so that it's part of the record as well.
So if I was there, where will I be at?
My understanding, if you choose to be there, is you will be escorted like you are in court here now. The bailiffs would be with you. You'd be in your suit.
No, where will I be at?
You would. I don't know exactly. That's up to the sheriff's department as to where all the parties are going to stand. Obviously, you would. We're not going to commingle you with the state or the state with jurors or you with the jurors or the court or anything like that. We're kind of. My understanding is we'll have sort of assigned places, and that it's only myself who will walk around. And I may not even do that. I have to think about that. But the jurors are the ones who are going to walk around the vehicle one time.
So I don't get to walk around the vehicle?
I can have you do that before the jurors come in. I certainly can have you do that if you would like. I can give the parties that opportunity.
May I add something else, Your Honor? I agree with everything the court said. I also think Mr. Brooks should understand that it will be a fair process. He's not going to be led into the room in shackles in front of the jury. What it's my understanding from Captain Dussault, the attorneys for the state, the prosecution team will be in the room. Mr. Brooks will be in the room. We will be in our assigned location. It will be fair. It will match. There will be basically no distinction between how Mr. Brooks appears to the jury versus how we appear to the jury. We will be in there first. If the court's willing to allow him to walk around the car one time to look at it, we have no objection to that. And then the jurors will come in. No one will speak. They will do one lap around the car. They will leave the room, and then the parties will leave the room. That's my understanding, Your Honor.
And I will add to that, because it's been a while since I had some preliminary discussions with the Sheriff's Department on this, that if However many bailiffs, sheriff's deputies are with you, I want the same number with the state, right? And that's what we mean by it will look no different. So each party will be accompanied by deputies.
I have a question to that.
Okay.
How come none of that knowledge of how it would be conducted was discussed with me? I didn't know anything about how the bailiffs would actually do things, how certain things would go. This is my first time hearing this.
Well, we have
So
preliminary.
I don't understand it.
We had preliminary discussions at the time of the request back in August when you still were represented by counsel. And then I had some additional preliminary discussions, if you will, internally with court staff, which included Captain Dussault and someone from the jail to talk about it and the logistics of it. And then, of course, we're having the discussion now, which is, again, why there's no jury here now. I wanted to wait until the appropriate time and then make a record of everything.
But don't you
At no
think-
time did I have conversations independently with the state.
Don't
They
you-
had filed a letter at one point because they themselves had, again, my understanding, and Attorney Opera can correct me if I'm wrong, had some discussions with, to see if it was feasible. They had some discussions with Captain Dussault. And Captain Dussault is with the Waukesha County Sheriff's Department. Of course, the Waukesha County Sheriff's Department and the sheriff is statutorily responsible for the security of the campus, security of the courtroom. And so that would be the proper person for any party to have discussions about a piece of evidence such as this. But I did not have any discussions with the state myself. That only happened in the setting of a courtroom or when a letter was received and I reviewed it.
I haven't reviewed that letter or seen it. Don't you think that?
It was specifically addressed at the jury status hearing, at which time he was represented by Attorney Perry and Attorney Keys. It is on file, and it was addressed by this court, many of these details, Your Honor.
All right.
Many of the same
So-
details that's being discussed right now at this moment?
All right, Mr. Brooks, do you have a request as it relates to any of that?
Well, yeah, I'm still trying to understand the whole how this is all working, and then it was a reference to how the shackles would look, or how being shackled or not being shackled. I'm guessing that I can't just walk around freely with bailiffs. I'm sure there would be some type of shackles.
I will tell them you are not to be shackled visibly for the jury to see.
And what do you mean by visibly,
And-
Your Honor?
So, obviously when you sit in court, you're shackled to a table. They can't see that. I'm not going to have you in belly chains or in leg shackles. You're just going to be escorted. And it will be up to them how they determine.
Well, he may be in leg shackles, Your Honor, if there's a table or some way that they can keep that out of the view of the jury. Just like he is in court. He's shackled in court. He has been for 3 weeks.
Actually, these are
The security has to be left at the discretion of the sheriff's department.
Actually, these are
Exactly.
leg shock devices, not shackles.
Sir, the security is up to the sheriff's department. I should be careful not to overstep my bounds on that. And, you know, whatever is done, it should not be viewable or visible to the jury.
And why is that, Your Honor? I don't understand that part. Why is the jury not privileged to see
That is to your benefit.
shock?
I'm not going to explain that any further.
I don't understand. I'm just seeking to understand. I don't know.
All right, I need to move on. So unless there's a specific request, other than a statement that
Yeah.
you're making about your lack of understanding, I need to move on with the other topics
There is
I
a
need to
specific
cover.
request. Why do I have to have ankle shocks on my ankles to appear at this jury view thing?
I guess I'm not aware of what you're talking about. So were you advised by the sheriff's department that that would be the case?
Well, the DA just said that I would have the ankle shocks on.
No, shackles, she said.
No, these are not shackles. They're a shock
Judge.
device.
Judge, I think perhaps we can move on.
All right, it is clear that he did have a shock device on. That he had to have had a shock device on. Why don't they argue about Brooks's favorite color? Exactly, Anna. Very good point. And Moki said she fell asleep. Scared. So, yeah, definitely. And it is. His attorney should have advised him better. And as I said, he does what he wants to do. And very good point, Anna. So, yeah, he had a shock device on. He is just going on a rant. And as I said, I don't know. I know what's wrong with him. He's a psycho. Okay, I know that. And he certainly has a temper and impulse control. She needs to stop playing with him. A lot of BS on this judge, okay? And like you said, I thought you were quiet. Oh, yeah. Shout out to all the lurkers and people watching. I appreciate it. And now, as I said, I do think she was patient, but and also Anna's like pointing out that he is playing a manipulation game, and then she's like arguing along with him. And I can understand where a no-nonsense approach, where they would not make a spectacle out of it on either side and just get to the point, or he could just shut up and do what he's supposed to do. So yeah, I definitely understand your position. And as I said, they were concerned that there would be a mistrial, or if he was mistreated, they would maybe he would argue, try to get a retrial. But definitely, I think that is also a good approach, Anna, because a lot of times manipulators like him will try to egg you on to manipulate an outcome to lead you down a path of playing a game with them. Mark Twain said that if you debate an idiot, they'll drag you down to their level and beat you with experience. Like it's like, yeah, definitely, it's a distraction. He's doing a filibuster. This is no nonsense. Zap him then. Yeah. Exactly. That certainly would be, the way to deal with it. And with that approach, like with Lori Daybell, they had a shocking device on her. Yeah, definitely would be a way to deal with that. With a no-nonsense way, yes. And Joe said, glad he didn't skate. His actions were absolutely unacceptable and deserves the most severe punishment, DP, in my opinion. Yeah. Absolutely. So, and he buried himself deep. And I mean, back in any other time period, and also Anna says, in case you try to run stupid. Yeah. If he tries to run, or tries to get out of there, or tries to attack the judge, that's another reason why to have the shocking device. Indeed. So, especially in other time periods, I would say they would certainly not deal with people like him. They would just shock him and throw him away. Definitely. All right. Continuing here.
I think maybe because this is going to have to occur on a break, the bailiffs can take him down there if Captain Dussault is willing, show him what it's going to be like, show him how he's going to get there, and he can decide at that point if he wants to be there or not when the jury comes in the room. We're spending a lot of time talking about security and things that are frankly beyond your knowledge and my knowledge.
I object to that. I'm simply trying to understand, why do I need ankle shocks?
I'm going to leave the security. I'm not going to make any specific orders. I'm going to backtrack a little bit. I will leave the security of the jury view to the Waukesha County Sheriff's Department. That is their responsibility. And I trust that they will do what needs to be done to maintain the security, no different than what they do here. And in their discretion will determine how best that takes place. And if I need to address anything after that or at that point in time, then it should be brought to my attention, but we are going to move on this morning.
So I should discuss that with the sheriff?
Yes. So I know, Mr. Brooks, you filed with the court 2 documents. I'm going to take them under advisement.
No, it's one document. It's one. It was 2 papers, but it's 1 document.
Oh, all right, thank you for that clarification. It's 1 filing, 2 papers, just front side, entitled Alleged Defendant Jurisdictional Challenge and Mandatory Judicial Notice by Affidavit. It references the case caption, the case number. I will simply take it under advisement, and I'll review it later, and if I believe it needs to further be addressed, I will do that. But it's my understanding, sir, that you are requesting the original back. Is that true?
Yes.
So normally, just so you know, when documents are filed with the court, we maintain the original until it's scanned in and it's audited, and then because under the statute, once it's e-filed or into the electronic filing system and the electronic case, I believe we just destroy the documents at that point. So I don't have an issue giving you back the original, but it needs to run the normal course. My clerk needs to scan it in. I've advised you of this previously, but in the courtroom, we don't have the time stamp. We just have the date stamp. I will state for the record that you provided this. It was right away at the beginning of the morning, so at 8:30 a.m. is when it was filed with the court, so that will be on the record. And then at some point today, when we're on a break, my clerk can scan it in and then provide the original back to you, and then I'll have the electronic copy to review.
Yeah, and very good point, chat. So, Ab said, bet this man never got an EOS whooping from his parents entitled Trial He Is. Yeah, he came from a broken home. He completely was not, in my opinion, disciplined. He was raised around, probably around people that were very emotional, and then he became emotional too. So all that, and not having a good parental figures in his life, led him to acting like a child, because he's still a child in a man's body with more aggression. It's different than like a kid on the playground. But yeah, I said it's completely like a kid on a playground. He does not act like an adult. And when someone's not disciplined like that, when they don't get put in line, they're going to act like these type of people. Definitely. Anna said, every time he says he doesn't understand, tell him that's why you should have a lawyer, period. Move on. Very well said, Anna. Absolutely. He goes in circles. Yes, that's a manipulation he uses. He likes to do this thing where this is why they'll say someone's like sane to be on trial, but he doesn't mean that he is good. Anna said, judge is overly enabling his BS. Okay. And in this situation, he completely is manipulator. He's a master manipulator. That's another thing about him. He keeps on trying to orchestrate a filibuster and cause confusion. Because people are evil, and like Abby and I were talking about in another stream, how there's just evil people out there, and yeah, he's one of those evil people. Oh, yes, Abby. And shout out to all of you for being here. I appreciate everybody hanging out with us. I'm really enjoying this trial hangout party. I appreciate all of y'all's takes. Very brilliant. Okay.
Address as I deem appropriate. Here you go, Madam Clerk.
I want to say to that too, in reference to that, I actually said on record numerous times that I wanted the original copies of all my filings. I've actually said that 3 times on the record. This would be the 4th time.
Every filing that I'm going to give it back to you, sir, but I'm not required to by law.
Well, I'm just saying on record that I've asked for that numerous times.
Your statement's noted for the record. All right.
So would I be able to get all the original copies of all my filings?
I'm not going to address that any further, sir, because I am not the official keeper of the record. As to what was filed this morning, as a courtesy, we will provide you back with the original once it's scanned and it's in my electronic file.
I was told that you make the decision if I can get the original copy.
And I just made a determination you could have the original back of this
Can
one.
I have the originals for all my filing?
I'm not going to address that right now, sir. I don't have time, frankly, to look through everything that you filed to determine whether we've given you originals or not. In the future,
I have the copies. I don't have the originals.
All right, I'm going to move on.
I have
sir.
them here.
This is taking up valuable time with the jury. We need to tomorrow.
All right, this one is Judge axed for that. Judge shuts down Darrell Brooks' claim over shock restraints. So this is, she goes off on him allegedly. Let's see how this goes.
Clerk's office is instructed that first thing tomorrow morning they may unseal all of the search warrants in this case. The next issue I want to address is I want to make a record specifically as it relates to the restraints that the Sheriff's Department utilized during this case, given a comment made by Mr. Brooks when the jury was coming out the very last time. I don't recall if you said something about a stun belt or shackles or something to that effect, but it was inaccurate. I have asked the Sheriff's Department to provide photographic documentation of the shackles that were utilized in this case. The parties will recall the tables look a little different now because there are no table skirts on them. On all defense tables in the secure courtroom, there is a
very good eye there, Joe. Already self-incriminated and continues to so it's rock solid. His right to appeal will be seen and immediately denied. Ah, very good. Very good. Yeah, someone sneezed. Bless you, whoever sneezed in the trial. All right. His unshaven neck pubes.
ring. It's really more looks like a rectangle that is attached to the leg of the table, and an inmate who's in custody but in trial, a soft restraint system is utilized, primarily so it's soft and not heard, and then it's attached to the table so that it confines
the crab hide.
Inmate to a small area with that table. Obviously during the trial, Mr. Brooks was able to stand. His hands were free, but I felt it important to have a thorough record of the restraints that were utilized.
Good night to you, Becky. Stay safe, take care. Thank you for hanging out with us. Yeah, Abby. Ski-aired.
The photographs that have been provided are on a compact disc. They will be filed as Court Exhibit 3, but they will remain under seal. And that is because of the security concerns related to how the Sheriff's Department secures inmates during a trial. That certainly is an overriding interest, overriding any public interest to see what those restraints are. And I would just further note that during the trial, when Mr. Brooks would be brought from the holding area into the courtroom, this courtroom was closed to the public.
Look at that, Timu stare he has, evil look in his eye. He really is, he's really twisted, very twisted, indeed.
And that was really to maintain that privacy, if you will, or secrecy, if you will, regarding the restraint system. And so
that stare is certainly intimidating. Like we were suggesting, she would probably tell him to stop looking at her like that and have order, because that's what he's trying to do, like a predator trying to hunt its prey. It said everything he does is very manipulative, in my opinion.
I believe it's important that that information not be released to the public. It will be available, of course, to the court and the parties.
Neck pubes. In fact, Joe. Yes.
And if there is an appeal, any attorney that may represent you can certainly look at that, but it'll otherwise be under seal. So
Why would
the
that-
record is very clear on the restraint system that was utilized during this trial.
I have a question to that.
Okay?
Why is that remaining sealed, but everything else being open to the public?
I've indicated my reasons are on the record. I'm not going to restate them. So.
Well, I think that the public, if they're allowed to see search warrant information and things like that, then I think that they should know that it was a shock device on my ankles. That
There was no shock device.
It was
your
a
ankle,
shock
sir.
device. I was told it was a shock device.
Mr. Brooks.
And
that's
it was
why
covered
I'm making
up.
the record.
It was covered up by black cloth, so the jury purposely could not see it, and so that the public cannot see it. I was told that a chair had to be placed on my side so that no one can see that I was shackled with ankle shocks. I think the public should know that.
Well, this is the thing about this guy is like, he needs to be concerned about the victims he had. And he's just said, very manipulative tactic. That's the only thing he's concerned about. And they should have probably used the shocking device, in my opinion, once or twice. You know, they didn't do it for their reasons, but yeah, he fought back against them. See, he is ruthless, all right? He's certainly ruthless, and he does not care. That's why I could see where people could think that a counter approach would have been effective too, from the judge's side. And as I said, I think the reason why they did it the way they did it was they were concerned about a mistrial being raised for some reason, or a misconduct. But he's the one with the misconduct. And as I said, the important thing is that he's locked up the rest of his life, and he'll never get out. So that is a good thing, and he won't be hurting any other people. But at the same time, in this time and place and space, there are people that are like him out there, and you all have to, understand that when you see someone acting like this in any situations, it could be a Darrell Brooks type person, and seeing how this historical event happened in this trial. Right, and Ab says, he runs his mouth so much, it's enough to cause a manic depression. Yeah. It will definitely be a toll on the mind. Absolutely. D-Sauce says, Brooks is very believable. Best regards, Richard Nixon. Yeah. Alright, continuing.
Jury should have known that. That's what they were.
Mr. Brooks, I've made my ruling. Your characterization
I respect your
of
ruling,
those
but it should be noted.
Your
it should
objection
be
is
noted.
noted for the record.
It should be noted that I had a shock device on my ankles. That's fact.
It
It's
is
a
not
fact.
fact, sir.
It is a fact. I'm the one that had them on my ankles. I inquired about what they were. Obviously, I'm going to inquire about what's being put on my body. I was told that they were a shock device, which I know how a shock device looks because I've been through this before in Milwaukee, so I know.
Yeah, and exactly, Joe. And so I remember, and I'll reiterate, when she was reading this very long documents before the jury deliberated, people are getting triggered in the chat, and they're doing it because legally there could have been something that was raised, against them. Sharon said, TY Alien, gotta make dinner. Good night, everyone. Take care. Okay, Sharon, good night, everyone. Good night to Sharon. Thank you for hanging out with us. We've really been enjoying hanging out with you today. Take care. Yeah, and at the same time, I do think that a tough approach in some situations wouldn't have been a bad idea either. As what I said before, the no-nonsense approach. So I do understand both perspectives, and I do think it's a balanced view of things to juggle around in any situation that you see someone acting like this that's not a court. It probably would be a good idea to just, get them to shut it, shut the pie hole, so to speak. So yes, I think, a balance is also good too. I could see both perspectives of opinions about the way this was handled. All right. As I said, I like to have the chat give their take on it. I said really appreciating all of you with different takes on it. All right. Here we go.
I know what a shock device is. It was clearly a shock device that was purposely not shown to the jury or to the public. Purposely not. And then now you're saying that it's going to be sealed. Well, why should it be sealed? The
All right,
public
Mr.
doesn't.
Brooks,
All right,
you're-
here's another one right here, chat. Another manipulation tactic. He's asking her questions. When you ask a question with a question, it's a manipulation. He said he's doing this on purpose, completely orchestrated it nefariously. Okay, so I think this guy had no remorse or empathy for anything he did. I think he knew what he was doing was wrong, and he was just evil and selfish. Because yeah, when you ask a question, and as I said, I even think this guy is nerve-wracking. Of course, I'm keeping my cool, but I could agree he's very nerve-wracking. And that's the whole point. He wants to invoke a reaction. And the way, by not being moved by the reaction, the judge or anybody cannot be emotionally manipulated into falling into for his trap. But at the same time, of course, it's good to shut someone up when they're trying to act like this, of course. That's not two different things. So I will say that it's a tactic he's using to ask a question, to flip it back on her, to try to take dominance and power. Not one started or end with Your Honor. Exactly. Should had one around your neck, Darrell. You attempted to escape, elude, apprehension, flight risk. Yeah, and he went to someone's house. And he took an Uber, I think, went to someone's house. Yeah, he was running from the scene. So he was completely sane and knew what he was doing. You know, he wasn't just going kind of like, "Oh, I'm a zombie in space." Now, the dude was like, coherent about what he did. And yes, as I said, that is a manipulation tactic that, I'm not an expert, never went to college, but from the internet stuff that I've learned, asking the question is a manipulation right there, definitely, on his end. It's a strategic tactic. It's not out of his emotional anger. It's just, he's doing it intentionally. You know, if he had a better home upbringing, and he wasn't such a evil piece of shit, you know, he could have been a successful person in some other way, if he didn't choose this path. But he's using any kind of skills that could have been used for good for something evil. You know, that's what evil is, a corruption of good. Ab says a shock collar is a good idea. A shock collar, a shock mask, all the 9 yards, definitely. Exactly, he was aware of what he did and was horribly wrong. Yeah, definitely.
The public deserves
You've
to
made
know.
a record,
The
and
public
it's
deserves
noted.
to know about
And
things pertaining to a search warrant, but not the fact that I was limited by a shock device. That if I moved the wrong way, I could have got shocked with all this voltage.
it's absolutely false.
This man, all the voltage, bro. Like he's disrespecting victims and the judge and the court and the country. He should have been. They should have cranked it all up and went bam on him, and he would have just collapsed. I mean, but definitely, as I said, he's trying to invoke a reaction. In my opinion, he's trying to invoke a reaction. That's another thing. This man hid behind cardboard boxes. Yeah, very brave of him. You know, a very brave man with lots of big balls to do that. Absolutely. But as I said, that's what a child does. I will say, when I was a kid, you know, not too long ago, kids did stuff like that. They hid behind boxes in the playroom. I remember it. That's what he's doing. You know, he never was given a spanking, as the saying goes. And, you know, that's why we're talking about how completely just shutting him up would be another good idea where he would know to have respect.
False that you
That
had a
is
shock
not
device
false,
on,
and
sir.
you know that it's not false.
Well, I have the photographs
Well, show
that will be part
where's the
of the
photographs?
record,
Where's the photographs?
and they
You
will
just
be
said they would be
sealed.
Again, he's asking another question. Another question. As I said, this is purely orchestrated on purpose. Right, and Joe said, you're right, Alien. He's trying to invoke a reaction so he can cling for an appeal. Right. And as I said, I mean, there was and I talk about different things in the past, and there is a samurai, right? And he invoked the other samurai by angering him into dropping his guard down, and he kept on trolling him to evoke a reaction out of him, and that's what he got. You know, and then the samurai was able to defeat the guy. So he's using, as I said, these clever, I'd say, war tactics against the the judge in the court and everything like that. Yeah, it's like he keeps asking these questions, questions. He would ask about the books. Why are these books on my table completely red? I thought, how am I supposed to know I have an issue? It is the color makes you irritated, Your Honor. Like, see, that's another thing he could have done. Or this computer screen, it's always dirty. What kind of judge? What kind of court is this? What kind of judge are you? I've asked for this to be cleaned. You see, he could have. He's just saying gibberish, complete gibberish. And as I said, when appeals court happens, when the jury sees all of this happen, they see her conduct, and guess what? They will find him guilty, and he had 6 consecutive life sentences. If she were to have been invoked into something, there could have been an appeal. So that is the whole point. Well, in my opinion, why they chose this strategy against Darrell Brooks. But at the same time, I can understand the other position too, of completely shutting him down. And I could see Anna's perspective too, where the judge needs to say, take it up with the jailers and move on. Yes, and Anna, that's a very good point, because you are seeing his manipulation. You're seeing his filibuster that he's doing, and that to just stop what he's saying and move on to something else. That is also a very good point of view too. Very wise. And at the same time, I think that this balanced view of what could have been done is good to know for another situation, and how it was handled at the same time was getting him convicted. So yeah, definitely a good point, Anna, because a manipulator like this is going to keep on going and going and going and going. And Anna said not going to get appeal for a judge moving on. Yes, and that is also true as well. Very good. And Joe said he's got nothing to lean on. Yeah, and I will say for the judge to set boundaries is a good thing, to get him to move on, and to not be trapped in his web of lies manipulation, because he's going to go on and on and on. So yes, Anna, that is also a good tactic as well. That could have been implied in this situation, because she has put up with enough with him, and I think enough reasonable doubt would be raised for him to not get an appeal. And Anna says, need older male judge, case closed. Yeah, and maybe that would have been the better option that they could have had. That is also another perspective. Thank you for giving your take on it. Because he's going to keep on going and trying to use his manipulation tactics to prolong the process. And distract from... It's going to cut out the noise of distractions and just keep on the main tactic and position at hand. Right. Okay. Continuing with this madness. All right.
Why do they need
From
to be
public
sealed?
view,
Why
for
do
the
they need to
reasons
be
that I've
sealed from
already
the public?
indicated.
Why do they need to be sealed
Mr.
from
Brooks,
the public?
I need to move on to scheduling.
Can we move on?
Good night, D-Sauce. Thank you for coming. Take care. Thank you for being with us.
On the subject matter jurisdiction that hasn't been proved for the record?
All right, so
Can we move on to that?
Mr. Brooks, I really don't want to remove you from the courtroom today, but I need to move on.
I don't want to be removed, but you're not going to sit here and tell me on the record what was on my body when I was told what it was. That's inaccurate, and I refuse.
At a
Your
later
Honor,
point in time, I
Your
will
Honor,
put.
I refuse to sit here and let you make an inaccurate record when you know that it was in fact a shock device. That's why I had the black cloth in front of the table so it couldn't be shown. That's
not
why I
how
had
I
a
know.
chair sitting on the side of me that was told needs to cover up the fact that I had a shock device on my ankles. And I think it's very, very, very unfair, and it's dishonorable to get on a record and not tell the truth. I'm not trying to dishonor you, Your Honor. I'm not trying to disrespect you. I'm not trying to disrespect your court. I just want the truth to be told. That should not be sealed. If everything else could be open to the public, then the public should know that I had a shock device on my ankles. That was purposely not shown to the jury or to the public. They should know that.
All right, thank you, Mr. Brooks. I disagree wholeheartedly with your characterization.
It's not true.
Mr. Brooks, I didn't interrupt you. Please
It's not
don't
true.
interrupt me.
It's not true.
Mr. Brooks?
I'm quite sure there's cameras rolling right now because there are always cameras rolling. There's always audio on.
Mr. Brooks, I need to move on to
There's public in the
scheduling.
courtroom. I had a shock device on my ankles, and they purposely did not want to show that to you guys or to the jury. That's
Mr.
why I
Brooks,
can only move
I'm advising you.
here or here.
Mr.
That's
Brooks,
the
I'm
reason
advising
why.
you.
And I always had the chair right here. Everybody that came to this courtroom seen that I had a chair right here, even though I had no counsel. What is the reason for me to have a chair right here?
All right, Mr. Brooks,
Why did I have a black cloth
any
in front of the
further
table?
interruptions will result in you being removed to the other courtroom
Okay,
because
and
you're
you
not
hold me
letting
in
move
contempt,
on
that's
to
okay.
scheduling.
Is it civil contempt or criminal contempt?
All right, one more interruption and you will go to the other courtroom.
Well, they need to know that.
Stop.
They need to know that. They need to know the truth.
I'm going to ask the state some questions. If you interrupt when I do that, you will be removed to the other
Okay,
courtroom.
remove me then.
All right,
Remove me
Attorney
then. It's
Basie.
not gonna stop the fact that they need
All
to know
right,
that the shock device
he's
is on my
interrupted.
ankles.
I'm sorry.
Yeah, and look at this. You see, the prosecution just wants to continue with what they're doing. And I can... Yeah, and I can see what you're saying, Anna. I can see. And also, Joe, also your position too, yeah. And it's good that he's locked up for a long time. It's good for you locked up for a long time, and he won't be getting out. And, yeah, there is a certain point where to zap, right, there's a certain point where you can let it go on and be like, look, we're going to do the, cut the nonsense right here. And, right. And very good point, Joe. Exactly. So, continuing. Yeah, because the prosecution just wants to continue.
Sorry, everyone. We'll have to clear the courtroom. He will be removed to the other courtroom. I'll make the
That's
appropriate
fine.
findings.
Tell the truth, though, Your Honor. Tell the truth. I had a shackle.
Lieutenant?
I had a shock device
Captain,
on my
can I
ankles.
please see you? We're off the record.
This is where he's held in contempt.
Working. He can hear, he can see, at least the other individuals in there confirmed that that was the case. He was audible for a little bit when I first went on the record, but he continued to be disruptive, and so I did utilize the mute function of the technology so that I could make an adequate record. Although this is really a scheduling hearing today, I will make a finding under Illinois versus Allen that his conduct was did disregard the element.
Absolutely, Anna. And there's another time where he was, he hit the table really hard, and he stared her down, and with a very deadly stare. Yeah, yeah. Shout out to Anna. Yeah, facts. Zap.
Elementary standards of proper conduct, of decorum and courtesy. He was disruptive. He interrupted multiple times and challenged this court when this court was making a record regarding the restraints that were utilized throughout this trial. I'm not going to do it today, but I will at a later point in time. Perhaps after scheduling, I will have a deputy testify regarding the restraints that were utilized so that there is a full and complete record about what was utilized and what was not utilized throughout this trial. It is absolutely false that a stun belt of any kind was used on Mr. Brooks. I don't know if he's receiving that information from other inmates. But that was not utilized in this case. It was a soft leg restraint setup, if you will, where he was shackled his ankles with the soft restraints and the soft strap so that it did not make noise. That was all attached to the table, and it is absolutely true that there was a black table skirt on the tables, both the state's table, the defense table, in this courtroom. Despite Mr. Brooks believing that it was not done for his benefit, it was to shield.
All right, Moki. Good evening to you. Thank you for coming and being with us.
That information from the jury. It's also true that at all times when he has been brought into court, it's been before the court has been open to the public. If this court needed to remove him to the other courtroom, it was also done with the courtroom closed to the public. That was, of course, a security decision made by the sheriff's department. They are in charge of his security as well as the court security during any court proceeding in this courthouse. And it was their discretion and decision on what restraints would be utilized. And again, I'll go through that later and have a record made of what was utilized, including having one of the deputies identify what's on the exhibit. I'm not going to show that publicly. Again, there are security reasons. We don't, frankly, need inmates doing research or the public doing research on what these restraints are. There's an important security aspect related to keeping courts safe, keeping inmates safe, and that is why I'm sealing that information from public view so that their protocols and practices have that, frankly, veil of secrecy. It's important given the security issues. It's a law enforcement function, and that is my decision on that. As far as Mr. Brooks being in the other courtroom, again, I did that pursuant to the authority found in Illinois versus Allen. I did not hold him in contempt.
All right, Abby, good evening to you. Thank you for hanging out with us. And take care. All right.
Frankly, because it's a scheduling type hearing, I could simply have him taken back to the jail and he could appear by phone, but I've chosen to have him appear by video and audio means from the other courtroom. With that, I am going to address scheduling. I will be asking each party in turn how much time they believe they need to present their various sentencing remarks and whether anyone will be speaking on behalf. So I'll turn to the state first.
Thank you, Your Honor. To date, we have indications from the victims or their families that 36 people would like to either have a statement read or they'd like to read it themselves. We have approximately 5 to 10 others that would like to submit one in writing, which obviously wouldn't impact the time that we would need on the sentencing date. I would think that the state's comments would be between a half an hour to 45 minutes in total. So we're looking probably at about 4 to 4.5 hours. We will need some time to rotate victims out of the courtroom as they come in to speak, because we can't fit everyone in the courtroom at one time. So we'll need to get one set in, get another one to room 115 so that they can hear what's being said. So we're thinking 4 hours, and speaking with the families and the victims Wednesday after the verdict. I think there's a strong desire to have the sentencing before the anniversary of the parade incident, and that obviously is November 21st. In checking with people, November 15th, 16th works for everyone. Specifically, the 16th works for everyone that would like to talk. I know that this court obviously has court calendars. I do have other dates that would work. Unfortunately, those go out to the end of December, end of November, beginning of December. But again, I can't emphasize enough, there are a lot of families who are leaving town the week of the parade, and I think the general consensus would be it would be nice for them to have some finality to this before they leave, so that they're not around here at the time that a loved one was injured or killed.
By any chance, did you have an opportunity to look at my calendar and some of the jury trials and talk with your colleagues? I mean, one of the cases, for example, I have on the 15th is an attempted homicide trial. I don't know if that's going to go or not, but just like this court gave due attention to this case, I need to be mindful that that case has been scheduled since June.
I did not. I received these dates, although I believe that they were probably sent this weekend. I did not check my email over the weekend, so I did receive them this morning, and unfortunately I did not take the time to do that. We can certainly look right now. Do you know who's handling that attempted homicide from our office?
I believe that's Attorney Sitzberger.
Okay.
There's other cases as well, because it's rare that I wouldn't stack trials, right. And so there's also another serious felony matter with Attorney Thurston for your office. That one was scheduled in August. I have another one with you,
Yes.
Attorney Basie. I'm just looking at the number of Mr. Brooks and find out how long he anticipates his sentencing remarks and whether anyone. So, sir, I have unmuted you if you could speak to scheduling.
First, Your Honor, I would just like to say that I know you're well aware that I have ongoing matters in Milwaukee pending too. I have to be in court there in 2 weeks, and those cases are scheduled for trial as well. I haven't had the opportunity to speak with my representation over there because of the protocol that I've been on these past, I think it was 5 days since I last was in your court. I would like the opportunity to, now that obviously this was the big case, obviously. If it pleases the court, if it pleases you, Your Honor, I would at least like to get a disposition on what might happen there. I go to court there in 2 weeks. I'm sure that I would learn a lot more at that time. I'm not sure if I'm gonna have the same representation at this point or if something's gonna change with that.
Do you
So
know
that's
the
something
specific date that you're scheduled?
The 17th. That's for both cases. I don't know why they put both cases on the same date. And like I said, I don't know if anything's gonna change between now and then. But both of those cases are scheduled to go to trial. And like I said, with the representation there, I don't know what's gonna happen with that as of yet. There's been issues for months with that. I know that's something that Milwaukee has to deal with and not your court. But it would be a great help to me to at least be able to find out what I can find out about what can possibly happen there, and to also do any work that I may need to do on my end to prepare for that.
So I have looked at the dates. You are right. There's a hearing on the 17th at 2 p.m. The trial, though, in that case is not scheduled until December 12th. So my belief would be I could certainly see the judge in that case understanding if we had to go to sentencing, or I chose to go to sentencing on those dates. And it looks like, again, both cases are scheduled for those same dates.
Yeah, it was kind of weird to me. The way they scheduled both cases on the same day was just kind of like, I didn't really understand why they did it like that.
Well, let's talk about a related issue, and that is, do you anticipate anyone speaking on your behalf at the time of sentencing?
I do.
All right.
I do.
And do you know how many people you anticipate speaking on your behalf?
I don't know an exact number, Your Honor. Rough estimate, there'd be 20 or more. I have not yet spoken with everybody, obviously, because of the protocol that I've been on. I haven't had the chance to, essentially, some people will be traveling to Wisconsin from different areas, different states. And I know they've expressed wanting to be there to speak for that. But like I said, me, myself, not being able to have the opportunity to speak with them personally, I don't know exactly how many. And I don't know how many people will be coming from different parts of the states. I would ask, if it pleases Your Honor, to be able to have everyone that does want to speak and does want to address the court, to give them the opportunity to be here for that. I know there's as far as the people that are here in Wisconsin that will speak, one thing that they would stress to me is that how is everything gonna affect what's going on in Milwaukee? So that was like one thing that came up, and because I had totally forgot that the Milwaukee court dates were this close. And so I was just like, yeah, you're right, 17th, that's 2 weeks roughly. I don't know exactly where we're at in those proceedings. Like I said, there's still like some issues going on with the representation. I haven't been able to reach out. Obviously, I can't reach out from where I'm at, collect call wise. And I've had very, very limited interaction with the current representation in those matters. So I don't know what pleases you, Your Honor. I don't know what pleases the court, but I guess what I'm seeking is for enough time to know exactly who's going to be speaking, where they're going to be traveling from, and a little bit more information that I can provide to this court about the proceedings in Milwaukee County.
One of the things that I've done for other cases, and I know I was asked about this previously as well, and I would also offer it up to the parties, is I will also make available Zoom for victims, family members, including your family members, who would like to make a statement on your behalf. The only thing I ask, though, is I'm not just going to open up my Zoom to anybody. And so anyone who wants a relative, a victim, family member to speak, whether it be from the state or from you, Mr. Brooks, is I need to know who, no later than probably a couple of days before. I'm leaning toward scheduling this on the 15th, so that would be like the Friday before, which would be the 11th, so that when they come on the Zoom, they're identified, and then I let them in. So I understand your concern about the Milwaukee, but if I hold this on the 15th and the 16th, by your description of how many people, by what the state said, I think it's going to take about a day to hear the remarks from the parties, and then I would come fresh the next day to give the court's sentencing. And so probably a day and a half, but I'd set aside both of those days just to be on the safe side in case it takes a little bit longer for either of the parties to present their sentencing remarks.
Your Honor, I'm not interrupting.
Go ahead. Go ahead.
I was trying to make sure I didn't interrupt you.
Go ahead.
Your Honor, with all due respect, if it pleases the court, if it pleases your court, Your Honor, because of my situation, I could benefit from a little bit more time. I'm not asking for something outrageous here. Just enough that I can tie up some of my loose ends, get you the information that you need to be able, if someone has to be present by Zoom or whatever the case may be, or to find out if these people are actually going to travel. And also still be able to prepare for what I need to prepare for, because obviously I still, regardless to anything, I still have to be prepared to continue court proceedings. I still have to be prepared. It will really be a big help and a great benefit if I can have just a little bit more time to tie up the loose ends and get everything done in a timely fashion to be able to be ready to go and present what's needed to the court.
I understand that, sir. The issue the court has is, obviously, if I wait much longer than that, I would, out of respect for the victims, avoid the week of November 21st. That's also Thanksgiving week. I don't think that would be an appropriate time for sentencing. But then after that, I do have, my calendar is just incredibly full. I have some time off in there. I have trials almost every week other than the week that I'm off, all the way up through the week of December 19th. And then again, I'm off again for the holidays. I wouldn't, and so that puts us into January, and I'm not willing to do that. It's just, and plus I need to avoid the week of that trial in case one of your cases goes to trial. So I think I'm giving the parties ample time. I'm giving alternate ways for family members to speak, and that is by Zoom or in person, should they wish to be here in person. And I'm willing to clear my calendar even of those trials. Hopefully my trials resolve, but to the extent that they don't, then I will clear Tuesday the 15th. Wednesday the 16th, though, I would not start until later that day, given the meeting I have to chair for the Criminal Justice Coordinating Council, or Collaborating Council. So that's from 8:30 to 10. I need to talk with our executive director a little bit more because I know we have a special type of meeting schedule, and I don't know if it will go longer. At a minimum, it would be safe to say the afternoon on that date. And no matter what, that would still clear Mr. Brooks to be in Milwaukee on the 17th. I mean, we're one county over. It's not unusual to do an order to produce that close.
What I was gonna, oh, I'm sorry.
No, so I am gonna schedule it for the 15th and the 16th. The 15th will start at 8:30 a.m. And depending on, I mean, I'll be ready to go no matter what on the 15th. And if the state takes into the afternoon and then Mr. Brooks needs the rest of that afternoon or into the next day, I will certainly make those accommodations. I think I'm going to tentatively say we're going to schedule it for 1 p.m. on the 16th. And if anything changes, I'll let the parties know. And then I just need to know by Friday the 11th at noon who the parties are asking make their statements by Zoom with a listing of their names so that when they appear on the Zoom, because then I'll approve it, we'll release the Zoom information. I need everyone to be aware, though, including victims, you may not, your family members, and it may not just simply give this Zoom information out. It will be only for those individuals that are identified by the state as wanting to appear by Zoom. I want to keep a tight control over that. And if I don't see like a name either says a name that's been approved, like if, let's say you had a friend by the name of John Smith. If John Smith doesn't say put on their Zoom info John Smith, and it's just a phone number, I may not let them in. They have to be identified, can't just give it out to anyone. And it's only for those individuals who want to make a statement, since the proceedings will be live streamed as well, whether that be how we've been doing it throughout the trial or if I utilize the Zoom and the live stream I've done in the past, so that other people can watch it as well and to facilitate the smaller courtroom that we have. So that's my decision on that. And at the I want to just very briefly have, I believe it's going to be Deputy Kibler who's going to testify about the restraints.
Your Honor.
Yes.
But I'm not trying to interrupt.
Go ahead.
You said, when is this supposed to be? Because I'm definitely gonna need a little bit more time than the 11th.
Mr. Brooks, I've made my decision. The sentencing will be on the 15th and the 16th of November. Anyone who wants to appear by Zoom on your behalf, you must file a request in writing no later than noon on the 11th. The same is true for the state. Everyone needs to be specifically identified so that I can make the appropriate approvals And only those individuals who I specifically approved to appear by Zoom may be on the Zoom. The Zoom information can't be passed out further. And I'll create a special Zoom for that, and I'll make sure that I work with Teresa to do that and get that information when I approve that to the parties.
Your Honor, what if I'm placed on a protocol per the jail? What if
Mr. Brooks, that's between you and the jail at this point. If there is something you need to first go through them. I'm not going to step on their toes with their protocols. I'm sure they'll understand this is a very important sentencing for you and make certain accommodations. They've done that throughout this case. I trust that they will do that as they determine is appropriate.
they haven't done it for the past week when I went on a protocol without even telling them anything suicidal in nature, and I was still placed on a suicide watch protocol.
I understand that, sir. I need to move on because I do have calendar this afternoon, but I want to have Detective Kibler come to the stand. Hibler.
Your Honor.
Deputy, what did I say? Detective, did I give you a promotion? Sorry. All right. He's going to come on up to the witness stand. I'm going to swear him in, and we'll go from there.
For the record, may I respectfully object to your ruling, Your Honor?
It's noted for the record. All right. Madam Clerk, swear him in, please.
For the record, may I respectfully request a legal reconsideration
All right,
of your
Mr.
ruling,
Brooks,
Your
I'm going
Honor?
to have to mute you because I need to keep going and I can't have this disruption. Go ahead. Raise your right hand.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you, sir. Have a seat. I'll let you put your name on the record so I don't get that wrong. And so go ahead. Please state and spell your first and last names.
First name Nicholas, Nicholas. Last name Kibler, Kibler.
All right, thank you. And you are employed in what capacity with the Sheriff's Department?
I'm a deputy for the Waukesha County Sheriff's Department.
I don't think so.
You don't have a EVD? All right, sir, were you assigned to the trial of Darrell Brooks?
I was.
And can you tell us in what capacity?
My capacity was, specifically, my responsibility was Darrell Brooks, along with Deputy Stengelson.
And were you in court at the start of the trial on October 3rd?
I was.
And did you come into court or work the court trial every day that we were in session?
I did.
And can you, were you at all in charge of the restraints? Let me ask you this way. Do you have knowledge of the restraints that were utilized on Mr. Brooks throughout this trial? Can you describe those, please?
It's a soft restraint that we used. It was not any type of electronic control device. It was just a soft restraint that we applied to Mr. Brooks prior to coming into court every day.
And would that be a restraint system that was on his legs or something else?
It was around his ankles.
All right. Throughout the trial, the tables in this courtroom had black table skirts. Do you remember seeing those?
I do.
And did that hide from view in any way the use of the restraints from the jury?
It did.
And were the restraints also attached to the table in some fashion?
They were attached to the table by a tether.
At any point in time, were there any other restraints utilized in the courtroom?
There was not.
At any point in time, were there any type of electronic or stun device placed on Mr. Brooks?
There was not.
Anything you would want to add to the record regarding the restraints that were used in this case, sir?
Not at this time.
State, have any questions?
Just briefly, Your Honor. Sir, you indicated that the restraints were connected to the table through a tether, is that correct?
Correct, and then we would secure them with a padlock.
And how long was that tether?
The tether that was in here was 4 feet.
So Mr. Brooks could stand up?
Correct.
He could walk to his left briefly and walk to his right, is that correct?
That's correct.
And that was the same rule that the state had, that we had to stand up and use our table to question witnesses. That was the same rule that applied to Mr. Brooks?
Correct.
Okay, nothing further.
Mr. Brooks, you're muted. Do you have any questions regarding the restraint system as testified to by Deputy Kidder?
Yes, I do. And Your Honor, you can't practice law from the bench.
Your question, sir?
So none of your fellow deputies told me that it was a shock device when I asked what was being placed on my ankles at the start of this trial?
Not that I'm aware of.
Not that you're aware of? Do you know for sure that I was told that they were a shock device?
I don't believe that's the truth. I believe every time you had those devices put on, I was in there, and it was either myself or Deputy Stengelson putting them on, and I did not tell you that, nor did I ever hear Deputy Stengelson tell you that they were an electronic device.
So you were here every single day for every single moment of the trial?
Correct.
And you never heard any deputy tell me that they were, matter of fact, let me back up. Do you recall me asking what was being placed on my ankles?
That I don't. If you did, we would have told you it was just an ankle restraint.
And you said that it was an ankle restraint. Did it have any metal parts?
Yes.
And what are those metal parts?
Metal part is where a strap went through and the locking device.
And what are those, particularly, let's say if a defendant in a trial attempts to, let's say, attack someone, what would be the purpose of those ankle restraints?
The restraints we had on you would limit your movement, so if you did try to do anything, we would have had enough time to control you.
And you state that, well, the prosecutors stated that the same rules were in effect for the defendant as the prosecution, but were they not allowed to put up exhibits to go to the front of the courtroom and put up exhibits?
They might have a few times, but
The record will reflect it was one time in the presence of the jury, and after that I called them on it and said that would not happen. And then after that, it was only with the permission of the court and then outside the presence of the jury.
I don't believe that, Your Honor, you can practice law from the bench and answer the question that was asked to the...
Mr. Brooks, I'm in charge of the record, not you, and the record's going to be accurate.
I didn't say, well, it's not accurate. You're practicing law from the bench.
All right, Mr. Brooks, do you have any other questions for this witness?
Yes, I do. Yes, I do.
It has to be about the restraint system. Please
Okay,
continue.
and was I allowed to approach the bench and put up exhibits at any time during this trial?
you were not.
And so, how is it that the prosecution was able to do something that I was not able to do?
That's not for me to answer.
It's because of the shock device that was put on my ankles, correct?
There was no shock device on your ankle, sir.
I was told that it was. And you said that you don't recall hearing that being told to me, correct?
No, it was not told to you by me.
Yeah, by you, but you also said that's the point that I'm getting at. I'm asking the question. You said that it wasn't told to me by you. I've never asked you, correct?
You never asked me, but I also did not ever hear Deputy Stengelson tell you that they were a shock device.
I never asked you. I never asked you, yes or no?
No, you did not.
So do you know for sure if I ever asked any other deputies?
Well, considering I was in there when the restraints were being placed on you, I did not ever hear anybody while I was inside the bullpen while they were putting restraints on you.
So it'd be fair to say that you don't know for sure if I ever asked what the device was that was being placed on my ankles?
No, I can't be for sure.
So how do you know I didn't ask?
You don't have to answer that. That's argumentative.
I mean...
All right, the record's been made. Mr. Brooks, I'm cutting off the questioning. I'm just muting him for a moment. The record's been made. Deputy, you may step down. Mr. Brooks, if you have additional information that you want to provide to the court, I'd ask that you do so in writing and you provide the identity of any and all individuals you claim provided you with information that you were in a shock restraint. But I'll make a finding based upon the testimony of Deputy Kibler and also my knowledge of being in the courtroom every day and seeing Mr. Brooks being attached, meaning they would secure him to the table, they would unsecure him when he needed to move and other things. I'll make a finding that the soft restraint system was what was utilized, and at no time was he ever in a shock type of device. All right, with that then, ladies and gentlemen, it is going to conclude the hearing today. We have the sentencing dates. I would also ask that any and all written material that either side wants this court to consider also be filed by the 11th by noon. So that's November 11th at noon. That will give this court ample time to review it ahead of
All right, let's see. Oh, the microphone's on. That's good. I didn't think it was on. Okay. Yeah, those are some Darrell Brooks scenes. Let's see. Okay, now I want to do this other thing. Let's see how this works. All right, Anna's here. I'm going to see about playing some scenes from another trial that I have discussed with Anna before. Let's see. See. I have it right here. Just going to. Is there anything else? Okay. Here. Okay. Does it go down? So this is closing arguments from the prosecution of this Spectre trial. Thank you, 666, for the link. Okay.
So that
This is the prosecution closing arguments from the Spectre trial. We have there's different scenes from the Phil Spector versus California trial, and this is the closing arguments that Alan Jackson made back in that time. Okay.
that wasn't going to work. They couldn't show that she had suicidal ideation. They couldn't show that she had prior suicide attempts. They couldn't show that she had been diagnosed with major depressive disorder. They couldn't show any of that stuff about Lana. All they could show is that she was a normal human being. So what do? They turned to Jennifer Hayes and pumpkin pie. Y'all have been waiting for me to talk about that, hadn't you? Jennifer Hayes and pumpkin pie. What did Jennifer Hayes say? Jennifer Hayes said, Lana Clarkson and me and pumpkin pie were the Three Musketeers. Inseparable sisters. We were each other's confidants. We were each other's go-to gals. We were inseparable. We were connected at the hip. We were the Three Musketeers, according to Jennifer Hayes. I loved Lana. I knew everything about Lana, and I knew the real Lana, which is real convenient, by the way. Oh, all you people, everybody else, all the evidence that says that she was a happy person, oh, that was just the game face Lana. I knew the real Lana. I got down into the dirt with her. I knew the real Lana Clarkson. Really? Did you? One of the first things you said on cross-examination, actually it was direct examination, I think it was a faux pas, I think she wished she could have taken it back. She said, I'm Pie's memory. I, Jennifer Hayes, am Pie's memory. Pie has such a poor memory. Pumpkin Pie can't remember her name if I don't give it to her. She has such a poor memory that I'm actually her memory. What else do we know? We know that Tawny Tyndall, as she is wont to do, interviewed her. But amazingly, there's no recording of that interview. And she interviewed her with another person. She interviewed Jennifer Hayes right alongside another person. Who could that person be? Oh yeah, Pumpkin Pie. The three of them sat and chatted together, and what do you think they did? You think Pumpkin Pie might have helped Jennifer Hayes a little bit get her story straight? We're going to get to Pumpkin Pie in a second, and her motivations in this trial in just a second. But do you think that their testimony sounded just alike enough that it's suggestive that they might have gotten their story straight? One thing's for sure, you, folks, will never know. You'll never know. Because Tawny Tyndall and the defense made sure that those conversations were never recorded. So you'll never know. You have to ask yourself, whose testimony were you listening to when Jennifer Hayes testified? Was it hers? Was it Pumpkin Pie's? Roger Rosen even talked to Jennifer Hayes at one point. That wasn't recorded either. Whose testimony were you really listening to? And then we find out that Jennifer Hayes knows about the cottage. This is the inseparable sister, the person that is closer to her than anybody else. They trade confidences and intimacies. They talk constantly. They know each other's good moods, bad moods. I know the good moods, bad moods, and I, Jennifer Hayes, know the real Lana Clarkson. Really, how long has she lived in the cottage? Oh, as long as I've known her. Absolutely, I've known her 8-9 years. She's lived there the whole time. Oops. Guess she didn't get that one straight during her conversation with Pumpkin Pie. Lana Clarkson lived in the cottage for about 2 years, a little over 2 years. Jennifer Hayes doesn't even know where Lana Clarkson lived. I'm not saying they didn't know each other. I'm saying you have to question whether or not they knew each other in the way that Jennifer Hayes said they knew each other. Keep in mind, she's got no corroboration whatsoever about their relationship, except one person. Pumpkin Pie. Interestingly enough, you'll have available to you, and I don't suggest you do this, it takes a long time. Actually, I suggest you do it. What the heck? You got nothing but time anyway, right? We presented you with phone records, cell phone records from Lana Clarkson, cell phone records from Jennifer Hayes. Not one phone call in the last 3 months of Lana Clarkson's life. Not one call received, not one call made. Well, you know what? We're in an email society. They don't talk on the phone. They get together all the time and share their intimacies in email. We know what a prolific emailer Lana Clarkson was, right? So it must have been email. We'll give Jennifer a break. Oops. Not one email. Not one email in evidence that you have between Lana Clarkson and Jennifer Hayes. Whose testimony were you really listening to? Hers or Pumpkin Pie's? And then we have Pumpkin Pie, who without question has chased the limelight from the day Lana Clarkson died. With the memorials that she went to, having her own memorial at some club that she was promoting. She was so devastated, by the way, that she got up that next Tuesday. Lana Clarkson lost her life on Monday. She got up on Tuesday and promoted another club. Oh, I had to be dragged out of bed, and I was dragged out of, the grocery store, and I collapsed, et cetera, et cetera. Oh, please. She was promoting a club the next day. I'm not saying that she wasn't hurt by Lana's death. I'm not being insensitive to her hurt. I'm saying, can you really believe this sob story that Pumpkin Pie was trying to sell you? Let's think about this. You have to test the character and quality of her testimony on this witness stand. Because, folks, the reality is, if it didn't come through that microphone, or it's not presented to you physically, it ain't in evidence. All right? What comes through that microphone is evidence. So you can test how Pumpkin Pie acted and reacted. You can test the character and quality of her testimony just by how she acted on the stand. How was she dressed? Did she come dressed appropriately? Or did she look like she was looking for attention? Everybody thought about that. Of course, the defense got her cleaned up the next time she was called to the stand. Or somebody got her cleaned up the next time she was called to the stand. Did she really look like someone who had just lost her best friend and is in the trial of her best friend's death as she tries to give over the truth about her friend? Or did she look like she was trying to draw attention to herself, just with her appearance, before she even started talking? And I don't think I'm putting too fine a point on it when I say, in trying to determine whether or not she seeks attention for herself, is she the type, is she an attention seeker? She named herself Pumpkin Pie. I mean, it's not like she went home to her mom and said, you know what, I don't like Irene and I don't like Elizabeth and Laughlin, it's not really working for me, so I'm going to change to Susie or Joanne or Michelle. No, she said, you know what, I think I'm going to change my name to a Thanksgiving Day dessert. Pumpkin Pie. Someone who's, and look, she can change her name to anything she wants to. I don't care. I don't care about that. All I'm saying is you have to ask yourself, is this part and parcel of her attempt to draw attention to herself? That's what she craves. The attention on herself. She used Lana Clarkson in life to do that. Tall, gorgeous, beautiful blonde. And she's using Lana Clarkson in death to do that. To draw attention to herself. When we approach sidebar, again, you test the character and quality of everybody's testimony and you watch their demeanor. That's why they testify live in front of you, so you can watch their demeanor. What was Pumpkin Pie doing? We approached sidebar at one point, and Judge Fiddler and Mr. Rosen and myself and Mr. Dixon were all having a discussion at sidebar, and I glance over, and Pumpkin Pie has brought friends, a little entourage, who are sitting in the back of the court, and she's literally smiling and waving from the witness stand. In the murder trial of her best friend, smiling and waving at the audience, drawing attention to herself. And then you have the book deal. Didn't come out on direct examination, but on cross-examination, she admitted, oh yeah, there's something going on, there's a treatment there, and blah, blah, blah. Well, who would buy a book about pumpkin pie? I mean, really, if it wasn't for this case, who would buy a book about pumpkin pie? Is that something that you think, and you're smart folks, that publishers would try to publish a book about a LA club promoter that does clubs here and there? And I don't know. Maybe it'd be a #1 bestseller. I don't know. I don't think so. However, you change that a little bit. You tweak that a little bit, and all of a sudden, pumpkin pie becomes the star witness for the defense in the Phil Spector murder trial. Maybe that might sell a book or two. Chasing the limelight. That's pumpkin pie. And then, of course, we've already talked about whether or not Jennifer Hayes actually testified as Jennifer Hayes, or if there was some puppetry going on, and literally Jennifer Hayes had been given information by pumpkin pie, say this, don't say this, say that, which none of which, by the way, is borne out by the evidence. No phone calls, no emails. She was asked a question she probably wasn't expecting. How long has Lana lived in the cottage? Oh, the whole time I've known her, 8 years, 9 years. You know, hoping for the best. Oops. And then, as a Hail Mary, there were a couple of Hail Marys in here. When pumpkin pie was brought back to the stand, she said, oh yeah, and by the way, just in case you were wondering, by the way, Lana always has her purse on her shoulder. Why did that come up? Why would that come up? Because the defense knows good and well that one thing they can't get by, one thing they can't get over, one thing that will never, ever make any sense is that Lana Clarkson killed herself while she had her purse on her shoulder. Is having her purse on her shoulder more consistent with committing suicide, or is it more consistent with saying, hell, I'm ready to leave, I'm ready to go home? They can't get past that. They cannot ever get past that because it makes no sense, and they know it. So what do? Here's the Hail Mary. You know what? Pumpkin pie's like Mikey. Remember those Life commercials, the Life cereal commercials? Mikey? Give it to pumpkin pie. She'll say anything. Remember Mikey, he'll eat anything? You know what? We're screwed on this purse issue. We can't get by that. The purse is the purse is the purse. It's on her shoulder. How do we explain that? Oh, well, I got an idea. Just give it to Pie. She'll say anything. Have her testify that Lana constantly had her purse on her shoulder. Every single time she saw her purse was on her shoulder. So pumpkin pie comes to court and she says exactly that. I swear to tell the truth, the whole truth, nothing but the truth, so help me God. Lana always had her purse on her shoulder. And she's out of here. Really. Except for all those photographs that they forgot that they introduced at the parties and at the beach and in Hawaii and in Jamaica and at such and such table and at the Jeff Franklin park. And guess what? Guess what's missing? Oh yeah, didn't think about that, did you? Not one photograph has her with her purse in it. Not one photograph has Lana with her purse in it. They didn't think about that. We know that there is at least one person in this trial who admitted lying. An admitted liar, and that's pumpkin pie. She said, yep, I lied. It's got an excuse for it now. Oh yeah, I lied to Detective Tomlin. I didn't tell him the whole truth. Well, let's see about that. Her first statement to Detective Tomlin, as you recall, was Lana was not suicidal. Lana was never depressed. The only time she was depressed, Lana Clarkson, was when she actually broke her wrists a year ago. And I put my hands behind my back just almost unconsciously because that's how Lana fell. She slipped on a rug and braced herself and snapped her wrists. 21 fractures, 3 surgeries, pins, halos, literally pins drilled into her skin, through her skin, into her bone. Was she depressed then? According to Pumpkin Pie, yeah, she was a little depressed then. Well, my God, who wouldn't be? Who among us wouldn't be? You're not going to get up and click your heels and sing a happy tune the next day after you have spiral fractures in both your wrists. Of course she was a little depressed. Detective Tomlin, was she depressed on February 3rd? Is she depressed now? And remember, this statement came just hours after Lana was shot to death by Phil Spector. No, she's not depressed, and she's definitely not suicidal. Then Pumpkin Pie, chasing that limelight, decides she wants to talk to Star Magazine. She had a pathetic excuse about what happened, but basically it went like this. The family decided they were going to have some dignity about this case. They had suffered enough. They had suffered the loss of their daughter, their sister. They had suffered enough. This case was not going to be tried in the press. So they gave basically standing orders. Nobody close to us will talk to the press. Pumpkin pie, to hell with it. I'll talk to the press if I decide to. So at one of her clubs, this Star Magazine reporter shows up, and they have a conversation. And remember what Pumpkin Pie's testimony was when she started on direct examination, under direct examination by Mr. Rosen. The direct examination went something like this. Lana Clarkson was my best friend in the world. She was my whole world. She was my sister, my inseparable sister. She was my best friend. We talked 3 to 4 times a day. I knew her better than anybody. Star Magazine article comes out. An anonymous person who claims to be Lana Clarkson's best friend, her best friend in the world, someone she cares about, someone she shares confidences with, someone she talks to 3 to 4 times a day. Pumpkin pie on the witness stand, that's not me. I don't know who that is. That's not me. Right. So Star Magazine comes out, and rightfully so, the family says, you know what? You have broken the cardinal rule. We decided we are suffering, we're mourning, we have suffered the loss of our loved one, and you're out self-promoting at Star Magazine. You're done. You're exiled. It wasn't that formal. I'm putting more formal words on it. Basically, they said with dignity, you know what? We're not going to talk to you anymore. We're not going to give you information. You're not going to be sort of in the inner circle. And that drove Pumpkin Pie nuts. Because where does she want to be above all other places? In the spotlight, in the inner circle. So she wasn't getting information. Then she picks up Vanity Fair. Picks up that article in Vanity Fair. Begins to flip through the article. And lo and behold, the Kessel brothers' name is mentioned in the article. And she thinks, wait a minute. You know, I promote at all these clubs all over LA, and Backstage Cafe. They, or one or both of them, are owners or part owners at Backstage Cafe. That could be interesting. That could be interesting. I'm not in the inner circle with the family. Is there someplace else that I could bring attention to myself? She reads that the Kessels are actually the sidemen of Phil Spector. Not just acquaintances, not just buddies long past. According to the article, according to Pumpkin Pie, what she read and what she conceived is that the Kessel brothers were the sidemen of Philip Spector. Like sons to him. Wow, what a connection. And that's the guy that killed Lana. The next thing you know, the next time she talks to the authorities, her stories flipped 180 degrees. 180 degrees. Now, all of a sudden, now Lana Clarkson's suicidal. She's depressed. She wanted to kill herself. Kessel's Backstage. And as of today, she's no longer promoting at Level 1 and Barfly and China Bistro. She's promoting at one place. She gets all of her finances from one place. 100% financial support from one place. Where is it? Where is it?
Okay, that was a scene from the Spectre trial. It's difficult to find scenes from it on YouTube. Yeah, that's funny. Hello, Joyce. Yeah, that shout out to the Spaceship Cats. And all right, so those are some scenes from the Spectre trial, and yeah, this is these are the Spaceship Cats on the spaceship. Yeah, and in this situation, that was from the Alan Jackson. Although understand there's the other trial he was in where he was not really liked too much. This was an irrelevant trial about something completely different. And yeah, so he did his his closing, and also we saw his beginning, and it's a little difficult to find scenes in that trial on YouTube. Now, I think there's another part of the defense lawyer of the what's his name? The other attorney, which has nothing to do with Alan Jackson. Let's see if I could find that. All right, let's go over here. Oh, that's hilarious, Frog. That's hilarious. Oh, I didn't have pizza. Okay. Okay, let's see, they go this way, and as I said, I'm looking over to see if this is, if it causes the stream a problem or not. Let's see. Alright, so this one, opening statement. Alright, let's try the defense opening statement. This was not, and thank you, Anna, for suggesting this trial. And this one is not Alan Jackson. This one is the other scene. Now, it's not on YouTube from what I can find, but it's on the Court TV archives, which I'll play for you all. Okay. This is not Alan Jackson. This is the other, the defense of Spectre. All right, let's see.
May it please the court. Ladies and gentlemen, good afternoon. I haven't spoken with you since last week. I think it was on Wednesday of last week, so it's been a week. As you know, I'm Bruce Cutler, and I've come here to represent Philip Spector in this very, very serious matter. With the court's permission, I'd like to begin my opening remarks to you. those photographs we saw, the remarks we heard from Mr. Jackson are not evidence. Photographs are, the remarks are not. It seems from Mr. Jackson that he has a very, from his opening statement, which is not evidence, a very negative view of Mr. Spector. It seems from Mr. Jackson's opening remarks that he has depicted and described him in the most negative of terms. So it becomes a problem to alert you to what the evidence will show. Part of what the evidence will show is that being successful, accomplishing so much, achieving so much in life, doing so much for others, when you achieve so much, can come back to hurt you. Your car is too nice. Restaurant is too nice, the evidence will show. The hotel in Manhattan, Carlisle, is too nice, the evidence will show. Fame and success comes back to haunt you. The evidence will show this was a tragic accident, and that it's a sad thing for any jury to see photographs that you saw. And the evidence will also show that back on February 3 of 2003, before they even had a cause of death, let alone a manner of death, they had murder on their mind. Murder on their mind. The police. According to Mr. Jackson, De Souza, a substitute driver with a language problem who was full of snacks and cookies and water and sound asleep, sitting in a closed car with the heat on and the radio on and the fountain going, could hear what Mr. Jackson claimed he heard. And that awakening from a deep sleep, which Mr. Jackson apparently did not mention, the evidence will show, he was able to be startled enough and to hear those 5 fatal words: I think I killed somebody. I think I killed somebody. I think somebody is killed. Or maybe he didn't hear anything. Because according to Mr. Jackson, the evidence will show that De Souza asked Mr. Spector, "What happened, sir?" And he received a shrug. But when I say to you, ladies and gentlemen, murder was on their mind, this is what I mean. This is a quote from Detective Fournier, I hope I'm pronouncing it right, and Tomlin, but I think it's Detective Fournier, Fournier, to De Souza in an interview in Alhambra on the 3rd of February, right after this incident. Quote, "This is going to be a high-profile case, no doubt about it. He's a man with a lot of money. He's wealthy, and it's going to be considered high profile. It's going to be in the news. It's going to be a big thing." And De Souza says, "What do I have to do?" And the detective says, "Tell the truth." And De Souza says, "I want somebody to direct me." And the detective indicates, "What you saw, you saw. What you heard, That isn't going to change tomorrow, next week, next year, or down the road. What I'm getting to, ladies and gentlemen, is that by the time Alhambra responded to the home, and by the time they spoke to De Souza, they had delineated and described this case as a murder. It had no alternative in their mind. It had no alternative in their mind. If the evidence shows you that the decedent, who's 5'11", was 5'11", 161 pounds and almost 6 feet in heels, and who was familiar with guns and firearms, and the evidence shows you that, and we prove that to you, and the evidence indicates to you that this was a self-inflicted gunshot wound, that at the time of the discharge of the weapon, of the gun, it was in her mouth, by her own hand, not by Mr. Spector's. And if science proves anything, and we prove to you that Mr. Spector was at least 2.5 to 4 feet away at the time of the gun discharge, and if you find from the evidence that...
Jackson argumentative, isn't it?
No, it's not argument.
The evidence will show that at the time of the discharge, from what we've seen and what we've heard, the decedent fired the gun herself. And I'm not suggesting to you, and I'm not saying the evidence will indicate to you that this was a suicide, but a self-inflicted gunshot wound, ladies and gentlemen, can be an accidental suicide. And if the evidence, and I submit, the evidence will show you that's the case. And the way we started today, early this morning, was that Mr. Jackson, who was taking Mr. Spector to task for being successful, said he ran with a haughty crowd. Haughty, H-A-U-G-H-T-Y. That means arrogant, supercilious. He doesn't run with, the evidence will show he didn't run with any haughty crowd. The evidence will show that Philip was born in New York, as I was, a city boy, lower middle class background. And that the evidence will also show, unlike Mr. Jackson mentioned, that at the age of 9 years old, he lost his father to a sudden, shocking death.
At this point, I don't know whether it'll be relevant, but I'm going to allow this during opening statement. If the offer is made that this is what the evidence will show, there may be a theory of admissibility. I'll allow it.
And that he moved here with his mother, Bertha, at 9 years of age. So, I don't want any of you to feel that somehow, some way, anything was given to Philip. Quite the opposite is the case. The evidence will show that he had a talent, and he worked very hard at his talent to make an impact in this world, in the world of music, and in the world of entertainment, and in the world of art. So when Mr. Jackson talks about these women, he mentions some of them, and that you're going to hear from some of these women who somehow, some way, had a romantic interest in him. The evidence will show you what the reason, what the draw, what the attraction was for them to be interested in Philip. Why were they interested in him? The evidence will show to you that in his way, he was a true and is a true romantic of a bygone era. He didn't chase any of these women. They came to him. They wanted to spend time with him. These were relationships that occurred between him and these women. They have nothing to do with the death of the decedent. Judge Fidler will tell you what, if anything, you can use with regard to the testimony of the other women with regard to a narrow legal issue in this case. But be assured and rest assured that these incidents to which Mr. Jackson referred go back as far as 30 years ago. At least one of them does, and the rest 20, 25, 18, 12, and 10 years ago. Not one of these women, not one, stopped seeing Philip. Not one of these women prosecuted him. Philip was never charged once for assaulting or hurting another human being. And he's in his 6th decade. Not one of these women came forward to them until after this incident. In this day and age, the evidence will show, with the excessive information that goes around the world, as you see from our friends here in the audience, after February 3 of 03, they decided, and the prosecutors decided, to come together. And they came forward at that time, or they reached out to them at that time. But if you listen to what Mr. Jackson, the prosecutor, said here, they had murder on their mind on February 3 of 03. Their case was de Souza right then and there. They didn't have any need at that time, the evidence will show, for a cause of death. They didn't have any need, the evidence will show, at that time for a manner of death. The evidence will show that when the coroner, who they will call in this case, had some misgivings and some doubts about how the decedent died, and wanted some further information about the decedent, the prosecutor's office at that time said no. And from February 3 of 03, otherwise, that there was some malice on the part of Philip, the evidence will show otherwise. The evidence will show that the decedent approached Philip. When she found out who he was, she came over to him. She showed an interest in him. When you sit back, take in so much, Mr. Jackson made such an efficacious and forceful argument, painted a man he doesn't know as almost a stark, raving maniac. And the opposite is the case. These other women have nothing to do with the death of the decedent. These other women had relationships with Philip. The decedent and she should rest in peace, had some difficulties with her life. I told you in the beginning, I will not besmirch the reputation of a decedent. I won't do it. But if it's relevant as to manner of death, I will go into it because it's relevant to clearing Philip of these false charges. And you'll understand and appreciate that she was 41 years old. She shouldn't have gone like that. How do I speak to you, jurors, after you've seen photographs like that? You probably want to strangle me. I don't mean that literally. But you're probably so against us, you think that there's something to it because of 5 words allegedly said to one taking a siesta. De Souza. He was asleep, he claimed at the time he heard the noise. That's what I learned is the term for it now. I'm not faulting him either. But 5 words to one person That's what they said. They've taken that and they've added, and what's called in the evidence you'll see is like an interstitial filler, like those foam peanuts you see in a box when you get a fancy present from a store, maybe a clock from Cartier if you're fortunate, or a clock from anywhere that works, and they surround the item with the foam peanuts so it doesn't break. But here what evidence will show when you open the box, it's just the peanuts. There is no clock in there. These women are being permitted to testify under the aegis of Judge Fiddler. They're permitted to do it. I submit to you that the evidence will show they're being called to assassinate Philip's character, to make him look bad, to make him look like something he's not. This is a man whose music changed the world.
Objection, Your
This is a man that...
The objection is sustained. That's going into argument.
This is a man that Hal Blaine, who was on the prosecutor's witness list, said in the 37 years I worked with him, I never once saw him with a gun. I never saw him in the studio doing anything off color. Ever. I've heard the rumors, he said. Problem is, out here, the evidence will show with the insatiable appetite for well-known people, the insatiable news about well-known people. Rumors begin, innuendos start, and stories are started. Fiction becomes fact. Untruth becomes truth. And that's what you'll see. And you'll see that even our great writer from the evidence, Tom Wolfe, indicated that back then, when Philip hit his high note, through the 60s, 70s, and the late 50s, he closed down his non-music life. He became a very private person. And so when you become a private person, then Mr. Jackson can show on the screen that he owned a home in Pasadena. The home in Pasadena didn't have a back door, but they say it anyway. Then he can say that he lived in Hollywood. The evidence will show that Philip never lived in Hollywood. Then he can show a photograph of the Pyrenees Castle, built in 1919. It was called the Pyrenees Castle when it was built, which is a landmark in Alhambra, and make it seem like it's some den of iniquity, and it's some private possession, and somehow was given to Philip because he came here from the Bronx with his mother at 9 years old. Nothing was given to him. He didn't mistreat these women. This is an example. The evidence will show that something terrible happened in his home. He was arrested for it, not charged until 10 and a half months later, not indicted until 17 months later, but he was charged with it because the police had murder on their mind. And that's how they went to the house. The evidence will show that when they approached Philip's home, they waited outside for 30 or 40 minutes. You listen to Mr. Jackson, the prosecutor, you think they were storming the Bastille. And they knew from D'Souza, if he was honest, that there was nobody in the house. The decedent died. Shocking, horrific death. Most shocking kind of thing. And the evidence will show you can't point a finger and have somebody pay for that because it happened in his home. The evidence will show that the prosecutor has to prove that beyond a reasonable doubt. Those are not empty words. That's the highest form of proof we have in this whole country. Shadow of the doubt is nice for Mr. Jackson to say.
Objection, Your Honor. This is
there is no shadow of the doubt.
The objection is sustained. You may proceed into opening statement.
Beyond a reasonable doubt, Judge Fiddler will tell you. That's the standard in this country. When they approached the castle and they saw Philip, they claim, according to the opening statement by the prosecutor, they saw him on the second floor. The evidence will show he wasn't doing anything improper. This was a shocking event. This was an event that shocks you to the core. So not everybody, the evidence will show, knows what to do. Not everyone, the evidence will show, knows what to say. Not everyone, the evidence will show, has worked for the EMS or the 911 folks. Not everybody has done that. And the evidence will show in a shocking event, people do things that sometimes are not explainable. And the evidence will show they're not consciousness of guilt, but their consciousness of terrorizing innocence.
Objection, Your Honor.
Consciousness of terrorizing.
The objection is sustained. Please return to your opening statement and do not argue the case. Thank you.
So, yes, Your Honor. So, ladies and gentlemen, when they approached the castle, and Mr. Jackson says the policeman gave Philip directives and orders, they told him to put his hands up. He did put his hands up. He invited them in. Said, come in. You've got to see this. There's a dead woman in my home. Whether he had 14 phones or 1,400 phones, the evidence will show how does that change anything. Whether he ran upstairs or walked upstairs or ran outside or didn't go outside, the important thing is at the time of the discharge of the gun, at the time the gun was fired, Philip was not holding that gun. We'll prove that to you. She was. Evidence will show that it's just so hard to, after seeing the photographs, evidence will show that playing with guns in a provocative or salacious manner can result in death. Instantaneous death, as Mr. Jackson said. A most horrific death. Completely avoidable. Completely unnecessary. A complete waste. But not because Philip is a man of note, not because he's successful, not because he had arguments with women 30, 20, 18, and 15 years ago. The evidence will show he never hurt anybody. He was never charged with hurting anybody. He never put a gun in a woman's mouth. He would never do something like that.
Objection, this is argument.
That has become argument. The objection is sustained.
The evidence will show you that. None of the so-called 1101B or incident with gun women to which Mr. Jackson referred will give that kind of testimony. The evidence will also show why they're coming. Why they're coming. The evidence will show that if we were in another site, another place, another city, another state, without the great cachet of Hollywood, without the great cachet of the entertainment capital of the world, and if Philip didn't have a name of major note because of what he's accomplished with his life, they wouldn't be here. They wouldn't be here. The evidence will show some of them peddled their stories to magazines, supermarket tabloids. He mentioned Miss Jennings. She's a freelance photographer. He called her a professional photographer. I like that. I like that. But she's not Philip. And neither are the other women. These were women who were drawn to him, and came back to him after these alleged incidents, to be with him. Some of them even called him after the February 3rd incident. Some of them even communicated with his daughter well after the February 3rd incident. So how is it the evidence will show did they decide to come forward now? What is their motivation?
Objection, this is argument.
That part, the last quoted words, is argument, and the objection is sustained.
The evidence will show, and I know you will look, to see where their heart is. The evidence will show that at times people act a certain way for their own benefit, the evidence will show. You might even see some tears in the courtroom. Evidence will show that some people, when they see another as vulnerable, falsely charged with the most serious,
The latter portion is argument, the objection is sustained.
charged with the most serious crime you could be. Former girlfriends, boyfriends, employees, paramours, so-called friends can really give it to you.
Once again, this is argument.
Sustained.
Just so it's clear, when you hear from the prosecutor, you get the impression that it is Philip who pulled and wanted to go with these women. This was a mutual relationship. The evidence will show that he took these women to the finest places. Now he's being punished for it. Took them to the rock and roll induction ceremony dinners. The evidence will show he himself was inducted into the Rock and Roll Hall of Fame some 20 years ago.
That may or may not come in. I'm going to overrule the objection at this point.
By his dear friend Tina Turner, who presented him. The evidence will show this is a man who spanned the years from Lenny Bruce through John Lennon. For those who don't know, Lenny Bruce was a political satirist in New York and all over, who spoke out. In fact, he preceded the great Richard Pryor and many others. He used to speak out in a strong way, and he was prosecuted and persecuted.
Objection. This is irrelevant.
The objection is sustained.
So if you want to know who Lenny Bruce is,
Objection.
that's who he is.
The objection is sustained. The jury's admonished to disregard. Anything where I sustain an objection, you're admonished to disregard it. You may proceed.
And Philip spans all the way from there through the John Lennon era. And you'll hear evidence that he worked with John Lennon. That was his dear friend who was murdered in New York. That he worked with George Harrison. That was his dear friend who died. That he worked with the Rolling Stones. That he worked with all these girl groups. That he extended himself to others. He made livings for others through his talent. He was not a taker, the way he's been described by the prosecutor, but he was a success and a talent who gave to others. That's what he was. Whether he became a private person because he closed off his personal life, his non-music life, as the great Tom Wolfe said, that's a separate part. But that doesn't mean, and you should never accept the thought which was put to you is evil there. Evil in the castle? Dubbed the castle? You've heard not one iota of evidence in this case, including my statement this afternoon and including the statement by Mr. Jackson. And if you were to go in the room to deliver a verdict now, you know what the verdict would be. So there's no more problem with having to worry about you prejudging the evidence. Because after today and tomorrow, you will be judging the evidence. But I submit to you, please bear in mind what I say. That a theory that the prosecutor has weaved in this case is just that. It's a theory. The ex-girlfriends who are coming forth have nothing to do with the decedent who he just met. Nothing whatsoever. Some people have arguments and say things and do things. The evidence will show that are not meant for a public forum. It's interesting to hear today about one of them Miss Melvin, and the prosecutor indicated that she worked for someone of note, and the evidence is going to show that Philip was friendly with Miss Rivers. That was his friend, somebody he knew. That's why he went to her parties. The evidence is also going to show that part of the cachet and the appeal to be around Philip Spector was because of the success he's had in life. And that does not mean, and as I said to you in voir dire, that he's looking for anything from you other than justice. This tough courtroom, where it takes you so long to get up, so long to get down, wait in line for lunch, our offices are not here. This tough, tough building is a temple of justice. That's really what it is, as difficult as it seems to be. This is a temple of justice. And as a temple of justice, you need to understand...
I'm sorry to interrupt. This sounds like it's getting into arguments.
It's getting close, but it hasn't quite got there. I think it's a precursor, so I'm going to overrule your objection. You may proceed.
This temple of justice is here for you to do justice, to analyze the evidence, to evaluate the evidence, to look at it with a careful eye, a judicious eye, to understand and appreciate it, to understand and appreciate why the prosecutor, the evidence will show, is going back so many years to bring up something that you may or may not think is relevant to this case. And Judge Fidler
The objection is sustained.
And Judge Fidler will tell you how to use it.
Objection. This is argument.
Sustained. Please, what the evidence will actually show as far as facts go.
When I mentioned murder on their mind, you'll see from the evidence that once the police department had a person of major note, and this has been going on for well over 100 years, well over 100 years out here, someone of major note had a death in his home, a drowning outside his home. The police have murder on their mind. And so because of that, they did everything they could to take care of Mr. De Souza, who called himself on the 911 tape Souza. He was here illegally. I don't fault him. There are 13 million people who want to come to the United States. He was here illegally, but he was working. I don't fault him for that. I don't fault him for that. I don't fault him for that. You're going to see from the evidence he had some animus and antipathy towards Philip. You'll hear from the evidence that he said to the police in his own speaking terms, and you'll consider and appreciate that this happened over 4 years ago. And he's been in this country under the aegis and protection of the district attorney with their help, and his English is better and is better and is better. And you'll try and think how it was 4 years ago when he first heard these things. And you'll understand and appreciate what they did for him and why. And the jealousy and the animus will be indicated by him on the stand. You'll hear evidence about that. Oh, other customers like to talk to me. Other customers speak to me. Mr. Spector didn't speak to me. Other customers, I went home at 2, 3 o'clock in the morning or 12 midnight. Mr. Spector kept me late. Kept me late. I submit to you the evidence will show that the decedent not only went there voluntarily, and I don't mean anything unkind about that, moved her car. I believe the evidence will also, and I submit to you, will show that she had a design of her own. She had a plan of her own. I'm not speaking against her. It's not fair. but I'm here to save a life. She had a design and a plan of her own. The people who worked with her and the people who knew her will indicate some of the difficulties she was having, financially and otherwise. We all do, everybody does. Even Mr. Spector, it would be a shock to Mr. Jackson. Everybody has them. Everybody has them. Difficulties and problems. Problems and difficulties. So the evidence is going to demonstrate to you that she saw an opportunity, and she saw something in Mr. Spector and Philip that would be beneficial to her. Beneficial to her. The evidence will show that sometimes an ornamental gun, I'll say it again, an ornamental gun can be used for all kinds of things, even though it's unsafe to do. It's unsafe to do. Policemen themselves, the evidence will show, have been hurt with their own guns. But the evidence will show she was fully familiar and facile with the guns and sidearms. She knew how to use them. And she was a big, strong, strapping woman. I'm not casting aspersions. I wouldn't do it. No matter what, I wouldn't do it. I told you it's not right. But you must consider the woman. You must consider the design. You must consider the plan. This stain for one drink, that's all coming from De Souza. I think I killed somebody, that's all De Souza. The whole case is De Souza and these other so-called victims. One who's a Miss Pileggi, who's a bank thief. You'll find out she stole from a bank. And the others who peddled their stories, they're not bad people. Philip didn't know Pileggi Grosvenor was a thief. When she romanced him, when she spent time with him, a sometimes romance, a part-time romance, a fling that goes on and off for years, and then ends, and there's animus and resentment, and then you have a problem, terrible problem, because a woman killed herself in your home. And so they come to your aid. And they give a story, a tall tale. That's what this case is. You'll see from the evidence, tall tales. He pointed a gun at me. He pointed it at my face. He cursed at me and pointed a gun. Well, then why do you keep saying them? There's no shrugs in Southern California. Not everything is shrugged off. Why do you keep saying them? Why do you keep taking his money? Why do you keep spending his money?
This is dipping into argument, so the objection is sustained.
So the evidence will show that they kept spending his money. They kept taking his money. Like as Mr. Jackson said, Miss Jennings had a suite, the Carlisle Hotel, a hotel he says he can't go to. Well, I'll take him there anytime he wants. There's nothing off color about the Carlisle Hotel. And the evidence will show they have a piano bar. And some of the most famous musicians, entertainers, and people in Philip's life spend time at the Carlisle Hotel. That's not a bad thing. That's a good thing. The fact that he's talented and successful, they're not bad things. They're good things, the evidence will show.
The objection is sustained. On that note, we will break for the day. Ladies and gentlemen, I need the parties to stay for a few minutes. There's an issue I want to talk about. I'm going to bring you back at 9:30 tomorrow. There may be some legal issues that we need to resolve outside your presence, and we may start late, but I'd like you here at 9:30. All right, keep in mind the court's admonition. We're in recess. Motion tomorrow for reconsideration of my ruling, which is fine. And
So that wasn't going to work. They could.
Tomorrow.
All right, so yeah, that was interesting. I appreciate, we could all agree to disagree under certain circumstances, and the and 666 was not angry. He he said, "I apologize as well. I don't like seeing arguing with people I like, especially involving people we don't know." And all good, Anna. Now let me ask you: have you had a lot of trick or treaters over there? So he was not. He was not angry. He was not angry. So he was distracted by something, some other task. And hello, Hazel. Good to see you. All right. Anna says, "Thanks, 666. I was out of line. I know you're intelligent, and I was stupid. We used to run out of candy. We had to use my Dove chocolates one year, but last year's almost no kids. Last year, nothing's. It's sad." Oh, yeah, now... Oh, that would be really fun with, like, a type of candy you do. Yeah, the trial happened during COVID. Dove chocolate sounds very delish. Very delish. Okay. They go to parties at the mall and have store employees dressed up and passing out candy. Okay. We could watch some of this Darrell Brooks. It's quite comical. While Hazel's here. Let's see. Cutler's jury leg room, living reliable posture. Okay. Yeah, trick-or-treating is different now. Some do trunk-or-treat parking lot. Yeah, sometimes there's messed up people out there. And I can see where people may not want to do what they used to. My kiddo is skipping trick-or-treating this year, movie night here. Oh, that's good. I hope you have a good movie. Now, these are some nighttime pumpkins, night jack-o'-lanterns. I have been watching the movie. I've been watching the Friday the 13th movies. Scared. Alright, yeah, so these are some jack-o'-lanterns. Shout out to the spooky season. Okay. And, just, yeah, I always like to put these pictures up during the, like to show them on the stream, these from the internet. These are some pretty cool pictures. Yeah, it's like politics, it could string a lot of strong emotions. And I think you all make a very great team working together. And we're not all going to agree on everything, and it's okay to agree or disagree. And I think I'm glad you all made peace with each other. And it was much better than things I've seen before in other areas of YouTube. So thank you all for respecting me in the stream and saying y'all's disagreements and then apologizing to each other. I really appreciate y'all very much with the situation. So yeah, but it definitely can. Definitely can. It can evoke strong emotions. And this one's pretty cool. Right here. Joyce, why do I think you will make him get out so you can help yourself to his bag? Scared. What I salvaged from Katrina was before the hurricane occurred. was this thing where it was this bag, this trick-or-treating bag that I brought with me and it didn't get destroyed. So that's pretty cool. I should have carved a middle finger into a pumpkin this year because that is how I feel. Yeah, there you go, Joyce. It's a way of artistic expression. Yeah. And it says, had to give out my stash because we had so many kids over the past 2 years. I got stuck with 2 big bags. Oh yeah. And yeah, sometimes it happens with the different trick-or-treater frequencies that occur. Now, hopefully this year they have some more trick-or-treaters in your region. All right, 666 says, some people do it, though. It's understandable. I just go with an open mind. But see, the thing is, no matter what happens in a trial, if someone is guilty or acquitted, it has no bearing on our lives. Yeah, similar to, I can say like with politics, like people we don't even know. And people have been divided over things like that. And I think politics is fine to talk about. But yeah, when it gets to a certain point, I could see where, we can't let it affect our personal relations because that's how it works, divide and conquer. And very good points. Anna says, we buy what we like. I paid $22 for a bag of good name brand candy. Oh, wow. Wow. That's you get the best kind. Oh, you never seen the first one? Okay. Okay, let's go here. Yeah, so shouts to these, different pumpkin fall scenes. Always like the fall season. It's a classic jack-o'-lantern. Okay. All right, I'll play some trial scenes. Entertaining trial scenes. Let's see. It'll be take our minds off these other stuff. Yeah, I might. Although, so we watched Brooks today. He was quite insane. See, it's cheaper to do the pizza and candy while watching a movie. Yeah, and also it sounds even more fun. And it says, I'm retired and think trials are much more brain work than soap operas, and I get caught up. Injustice pisses me off, though. I agree. I'm also pissed off by injustice. I agree with you, Anna. And I appreciate the passion that both sides and all people will feel about these things. It's just we cannot let it work against us and cause us to be ripped apart, which I'm glad that you all understand. And I'm not too sure. Let's go here. I might play although so we played Brooks earlier. Let's see about the other guy. Oh yes, I've seen the Ed Gein story. Oh, Joyce, I like the older horror movies too. I grew up watching them. Yeah, I've seen Ed Gein. I know, but the guy in Wisconsin that murdered he's a Texas Chainsaw Massacre basically. All right, let's go. I'm trying to think. Let's see. I am thinking. I'm trying to think. I think. we played, as I said earlier, today we played Darrell Brooks during the daytime. And I'm going to place a scene from the depth trial if everybody's okay with it. If anybody has no objections, I'm going to play some scenes from the depth trial that we didn't really see much of. It was a video we didn't really play that much. And we have Hazel here. And also, shout out to Hazel and the other people that are lurking, watching. I appreciate y'all and being patient with each other and chat. We'll now continue. Right, so, yeah, Darrell Brooks is locked up, thankfully, and won't be causing anyone else any more problems. All right. Is this... Let's go here. Let's see. There.
Relationship. There were arguments and things of that nature, but never did I myself reach the point of striking Miss Heard in any way, nor have I ever struck any woman in my life. And so at the time, because the news of this, her accusations had sort of permeated the industry and then made its way through media and social media, became quite a global let's say, quote unquote, fact, if you will. And since I knew that there was no truth to it whatsoever, I felt it my responsibility to stand up not only for myself in that instance, but stand up for my children, who at the time were 14 and 16, and so they were in high school, and I thought it was diabolical that my children would have to go to school and have their friends or people in the school approach them with the infamous People magazine cover with Miss Heard with a dark bruise on her face. And then it just kept it kept multiplying. It just kept getting bigger and bigger. So it was my responsibility, I felt, to not only attempt to clear my name for the sake of, well, for many reasons, but I wanted to clear my children of this horrid thing that they were having to read about their father, which was untrue. And also, after many years of being in this industry, at the time it was I'd probably been in the industry 30 plus years, 35 years. Never had any problems, anything like that. And I had met many people over the years, many of the people, and had the opportunity to talk to those people and to even give advice to these people. And I'm not, my goal is the truth. My goal is the truth because it killed me that people that I had spoken with, that I had met with over the years, who maybe were in a not such a great position and they needed advice, and I gave them the best advice I could. All I could think of was that those people would think that I was a fraud and that I had lied to them. And so I had to wait for my opportunity to address the charges, which were criminal charges. And they just weren't true. So I felt the responsibility of clearing the record as the only way that I could get to the point where I could speak has really taken this full 6 years. And it's been 6 years of trying times. It's very strange when one day you're Cinderella, so to speak, and then in 0.6 seconds you're Quasimodo. And I didn't deserve that, nor did my children, nor did the people who have believed in me for all these years. I didn't want any of those people to believe that I had done them wrong or lied to them or that I was a fraud. I pride myself on honesty. I pride myself on truth. Truth is the only thing I'm interested in. Other lies will get you nowhere, but lies build upon lies and build upon lies. It's too much to cover. I'm obsessed with the truth, and so today is the first opportunity that I've been able to speak about this case in full for the first time.
Mr. Depp, how do you feel about the intimate details of your life being aired in this process?
As a father, raising kids, when they were very, very little, it was important to me, very important to me, to try to shield my children as much as possible from looking at their father or their mom, for that matter, as novelties. I didn't want my children to experience hordes of paparazzis. So I was always a very private person. So for me to come up here and stand before you, or sit before you all, and spill the truth is quite exposing. And it's unfortunate that it's not only exposing for myself, it's exposing for my family, it's exposing for Miss Heard, it's exposing for... It never had to go in this direction. And so I can't say that I'm embarrassed, because I know that I'm doing the right thing.
Now, Mr. Depp, I'd like to turn a bit to your upbringing. We heard a bit from your sister Christy last week, but can you please tell the jury in your own words about your childhood upbringing?
I had a very interesting childhood, one that I thought was normal until a certain age. My mother, I was born in Kentucky, and then we moved around quite a lot. when I was a kid. So you were always just, my mom had this, her feet were on fire and she had to move, so we moved constantly. So you were always the new kid. And that wasn't ever particularly pleasant. Then we moved to Florida, South Florida, when I was about 7 or 8. And again, moved several times. But my mother was quite unpredictable. She was very unpredictable. She was she had the ability to be as cruel as anyone can be with all of us. That is to say, my sister Christy and my brother Danny and my sister Debbie, and also my father. So, essentially, she was, she could become quite violent, and she was quite violent, and she was quite cruel, and though there was physical abuse, certainly, which could be in the form of an ashtray being flung at you, it hits you in the head, or you'd get beat with a high-heel shoe or a telephone or whatever's handy. So in our house, there was we were never exposed to any type of safety or security. The only thing that one could do, really, was to try to stay out of the line of fire. I started to be able to observe, and I could start to see when she was about to head into a situation where she was going to get riled up and somebody was going to get it. Generally, it was me.
Mr. Depp, you mentioned that your mother could be cruel. How could she be cruel?
The various categories, I suppose, there's physical violence, of course, there's physical abuse, to which she was, that was a constant. That was just a constant, We were all somewhat shell-shocked, even if she just walked past us, you'd sort of shield yourself because you didn't know what was going to happen. Excuse me. And
I got some information. So, interrupting the program for this. All right, so about Depp's hide, it seems that from what I can gather, because I saw the video for it, the ad like what you all saw. Now, from doing some further research on this, it seems to be that Johnny Depp's graphic novel series Hyde is scheduled to be released on Halloween 25. And it seems to be a graphic novel. They made a video trailer for it, but it's a graphic novel. Seems to be the information I can gather at the time. And so it's not a movie, it's a graphic novel series. The project is collaboration between the actor Johnny Depp and filmmaker Ridley Scott. while a live-action trailer for the graphic novel was released, there has been no official announcement for a movie or TV series adaptation. The creators aim for High to become a fan-driven franchise that could potentially be adapted into a film in the future. So at the moment, the film is not... There's not a film at the moment or a TV show at the moment coming out, but it's a novel. But in the future, there'll probably be a movie of it. To just be a little bit of, I feel, just more direct about the situation. So the movie part has not been created yet. Joyce said, I was going to say I don't see him writing novels. Yeah. Okay. Right. So yeah, there'll be a movie in the future about it, but not at the moment. I'll certainly look into the novel, though. I'll certainly look at it. Definitely. All right, now resuming the scheduled program.
So there was the physical abuse, which was a constant. There was quite a lot of verbal abuse. There was quite a lot of name calling and bullying. You know, making fun of whatever defect, you know, one might have. You know, if my brother wore glasses, so of course he was four eyes, and his teeth were messed up in the front, so he was buck-toothed as well. My sister Christy, which this is such a hideous psychological play. My father's parents were quite refined. My mother comes from Eastern Kentucky, which is where you grow up in shacks and hollers, you know, and my mother despised my father's parents, and my grandmother's name was Violet, and every now and again you would hear my mother just scream across the house, "Come here, Violet, get in here, Violet." And Christy, my sister, knew very well that that was a deep cut, psychologically, emotionally. But we had to take it. I mean, you just had to take the pain. I was born with a very strange, it was a very rare thing in my eye, as the back of the lens is spherical. Normally is spherical, so in this eye it isn't normal. This eye, I was born with a more conical lens, so my brain never learned to see out of my left eye, and they noticed when I was about 3, 4, that I had a lazy eye, a wandering eye, and she would call me cockeye, one eye, anything she could get to demean, humiliate. I even had to wear an eye patch on my good eye to strengthen my bad eye, so that it would cease to wander. It was exercising the muscles of the eye, though the brain had never learned to see. So I still, my vision in my left eye is, I'm legally blind in my left eye. But so yeah, the verbal abuse, the psychological abuse was almost worse than the beatings, because the beatings were just physical pain, and the physical pain you learn to deal with. You learn to accept it. You learn to deal with it. But the psychological and emotional abuse, that's what kind of tore us up, I think.
What about your father? What was he like?
My father was a very kind man. In fact, my father's still alive. He's a very kind man. He's a very quiet man. In fact, he's very shy. Not a confrontational person in any way. And when Betty Sue, my mother, would go off on a tangent toward my father, and of course in front of the kids it was no matter to her. He amazingly remained very, very stoic, and never, as she was rationing him with horrible things, he stood there and just looked at her while she delivered the pain, and he swallowed it. He took it. There was never one moment, never a moment when my father lost control and attacked my mother or hit my mother or even said a bad thing to my mother. The things that I witnessed were, there were a couple of times when it got too far, that I could see his eyes welling up as he was staring at her, saying nothing. And then the most that he would do is he would punch a wall. I once saw him punch a wall and it shatter his hand because it wasn't drywall. It was proper concrete and steel wire and rebar and things of that nature. And but still, never touched her, never argued with her. He remained a gentleman, and to me, as a 5-year-old boy, I kept thinking to myself, I kept wondering why does he take it? How does he take this? And why doesn't he leave her? But he didn't, you know. He was able to maintain his calm and his composure. He was able to maintain his relationship with his children. He was a good man. He is a good man.
You mentioned that you saw your father punch a wall. How many times did you witness that?
I mean, out of I couldn't count the amount of fights that they had, but I know that I've seen my father strike a wall 2 or 3 times tops. Once when he broke his hand, but yeah, 2-3 times at tops, you know.
Was your father ever abusive to you or any of your siblings?
No, my father was not an abusive man. At the same time, my father was also, to some degree, at the mercy of Betty Sue, because if he argued with what she wanted done, and that would just turn into another barrage of hatred towards him. So I can remember my father coming home from work, and maybe I'd gotten a bad report card, or maybe I'd gotten in trouble at school, or something like that. And my father would arrive home from work, and the first thing she would say was, "John, take him out there. He gets the belt. Give him the belt." And he wanted to know what it was about, so he'd take me out to the garage, and I'll never forget this white, thick leather 1970s era, thick leather white belt that he would take off, and then he would commence to inflict the punishment on me. But interestingly, there was one time when my father, I kept telling him I didn't do this. It was another incident. I kept swearing to him that I did not do what Betty Sue, what my mom had said that I'd done. But he went through with the punishment anyway. And then, not long after, he found out that I had been telling the truth and that I hadn't done what my mom had said that I'd done. And he came to me and apologized to me for having gone through with the whipping, the belt. And I have to say, my mom never did that. She couldn't. She knew what she knew. She was raised how she was raised. And I had no power to change what was inside of her,
How did your parents' relationship ultimately come to an end, to your understanding?
When my father left, I didn't realize that he had left. He left for, I was 15. I had already left school, and I was a musician. I was playing in clubs and such. And he left for work one morning, just like every day, and was packing his car, and then he left. And then hours later, my mom, Betty Sue, came home from work. It was about 3:30 in the afternoon. And she walked in the door and stopped and just looked around like she felt something. And I said, "What's wrong?" She said, "Your daddy's gone." I said, "Yeah, I seen him leave for work this morning." She said, No, he's gone. And she ran into their bedroom and into their closet, and I followed her, and she opened the door, and there was his rack of clothing and all his belongings were gone. And she was quite upset, and I took her car and drove to my father's work, and I sat down in front of him at 15, and I said, "Listen, seems as though somebody stole all your clothes out of the closet." And he said, yeah. He said, "I'm done. I can't do it anymore. I can't live it anymore. You're the man. You're the man now." And those words didn't quite sit well with me. I didn't feel like I was ready to hear those words. But that's what I got. Then my mom went into a very, very dark place, a very deep, dark depression, as you can imagine. And one afternoon I woke up, I'd fallen asleep, and I woke up and walked out into the living room, and I saw my mother, very feebly, and like almost, it was like a slow motion crawl. If I could stand up, I could show you just what I saw. Do you mind? Do you want?
You can stand up.
Thank you. I saw my mother, in that mode. So instantly, I knew that something was dreadfully wrong, and there was drool coming out of her mouth. And as I was about to run and call, the front door busted open, and my uncle and 2 paramedics came in and threw her on the gurney and whisked her out of the house to get her to the hospital to pump her stomach. She had swallowed a multitude of pills to try to take herself out, to try to commit suicide. And when she got out of the hospital, she was a small firecracker of a woman. She was about 5'2". But when she got out of the hospital, the depression was so deep. She was down to she lived on the couch, and she weighed about 70 pounds. And that, all that imagery spun into my head at that time, that I thought that was in my head at the time, I thought that was a cowardly way for my father to have left. And I was deeply upset by that. Until my father and I had a conversation years later, where I asked him what really happened, how did it happen when I was older, and he told me the story.
Your Honor, may we approach? Sure. Mr. Depp, how did you feel about your father when he left?
I was very disappointed in him, because I started to believe that his exit was sneaky, cowardly. He when he said goodbye to me, when he left for work that morning, he just said goodbye, goodbye, Bob. And I went, see you later, Pop. That was it. Until I learned the truth from him.
And without getting into what your father told you, how has your impression of your father changed now?
Objection, relevance.
Your Honor, this is just an understanding of his perception of his family.
I'll sustain the objection. Next question.
Mr. Depp, what have you learned from your experience in your childhood and observing your father in your childhood?
I learned that I was wrong about my first impressions of his exit from the family. Very wrong. And I'll tell you one thing that I learned that was one of the best lessons I believe I've ever learned in my life, ever could learn in my life, was based on my experiences as a child and what I'd seen and experienced. I knew exactly how to raise children when my girl Vanessa got pregnant. I knew exactly how to raise children, which was to do the opposite of what they did, of what Betty Sue did. Never raise your voice in front of the children, never. Screaming out the word no to them. I never wanted to tell my kids no. I wanted to tell them that I wanted to show them that there were options. You don't have to stick the coat hanger in the electrical socket. You know, saying no is an abrupt thing, but to talk to them and say, if you understand the repercussions of something, then you won't go there. So maybe think about this as opposed to this. Give this some thought, you know. But that will clearly, that could kill you. So I would ease them away from things of that nature with a more of a conversation as opposed to a flat out, don't you ever do that again, and threats and things of that nature. I did not raise my children that way. Nor did Vanessa. We never raised our voices in front of our children, ever.
How do you think your experiences with your parents in your childhood affected your approach to your relationship with Miss Heard?
I'm sorry, one more time.
How did your experiences observing your parents as a child affect your approach to your relationship with Miss Heard?
Well, in the beginning of my relationship with Miss Heard, there was, from what I recall and what I remember, she was it was as if she was too good to be true. She was attentive, she was loving, she was smart, she was kind, she was funny, she was understanding, and we had many things in common, certain blues music and, well, music, literature, things of that nature. So for that year or year and a half, it was was amazing. There were a couple of things that, I don't know, stuck in my head that I noticed that I thought might be a little bit of a dilemma at some point. For example, I worked quite a lot, and when I would come home from work, I would come in the house or the hotel, and she would sit me down on the couch and give me a glass of wine and take my boots off, set them to the side, and I'd never experienced anything like that in my life. I just never thought I just never experienced that before. And it became a regular thing that she did, this kind of routine. And I remember one night I came home from work, and I think she was on the phone or something, or busy. She was doing something, and so I sat down on the couch and I took my boots off, and suddenly Miss Hurd approached with this look on her face and she just said, "What did you just do? What did you do?" I said, "What do you mean?" "You took your boots off." I said, "Yeah, yes, I did. You were busy, you know." No, that's my job. That's what I do. You don't do that. I do that." "Okay, all right then." And then she said, "Let me get you a glass of wine." And she brought me the glass of wine. But I did take pause, of course, at the fact that she was visibly shaken or upset that I had broken her rules of routine. I thought that strange. And then once you notice something like that, then you start to notice other little tidbits and things that come out. And then within a year and a half, she had become this another person almost.
Mr. Depp, we're going to talk about Ms. Hurd in a couple minutes, but I'd like to first talk about your career in Hollywood. And so could you please tell the jury how you ended up acting in the first place?
I ended up acting by accident. I was a musician, and I'd moved out to Los Angeles with my band when I was 20 years old. And then there were a couple of things that happened in the band where the band split up, and I remember I was filling out job applications, and then Nick, with a friend of mine who happens to be, he was an actor, less known then than he is now, Nicolas Cage. And I was filling out job applications at any, video stores, clothing stores, anything, just to be able to pay the rent. And Nick Cage said, why don't you meet my agent, because I think you're an actor. I think you could be an actor. And I said, look, I'll meet anybody, I'll do anything at this point. And so he sent me to his agent, Eileen Feldman, and I met with her. She sent me to read for a casting director named Annette Benson, who was casting a film called The Nightmare on Elm Street. They brought me back to read for the director, Wes Craven, and I read for Wes Craven, and somehow got the job. But I mean, I was by no means an actor. I didn't have any desire to be an actor. I was a musician. But the fact that these people were going to pay me what I found to be a ludicrous sum of money, which was it was kind of the SAG minimum. It was $1,284 a week, which I mean, you know, I'd never seen that kind of dough before in my life. And so I suddenly, you know, and then I did some other couple of dumb movies because I still, in my mind, I was a musician, and this was just a way to pay the rent, pay the bills, live. Then suddenly I found myself on that road. I had been placed on that road as an actor, and then one thing led to another, from film to film, and then I was cast in a TV series called 21 Jump Street when I was 22, I believe.
Mr. Depp, between the time that you were cast in Nightmare on Elm Street and you were cast in 21 Jump Street, how did you enjoy acting during that time?
It was foreign to me. It was foreign to me, but I didn't have any great ambition to be an actor. I'm a naturally, normally, I've always been quite a shy person. I've always been quite introverted. And so there was a very strange metamorphosis from being one of four, that is to say, one of four in a band where you have this fraternity or this brotherhood, and you're out there fighting the world together to try to get that record deal or whatever you're looking for. And when I got on this series and my life started to change in various ways, that is to say that people started to, you know, you go into a restaurant and you'd see people whispering and pointing and all that. I was very uncomfortable with it. I was very uncomfortable with it, and I didn't like it. Just because I never wanted to be the lead singer and the guy out front and will get all the attention, and I didn't. So suddenly I was on my own, and I was having to deal with this newfound sort of notoriety, and it was odd. It was very odd, and it was. Yeah, it was a very uncomfortable thing. I mean, I don't think it's anything that one can get used to. I'm still not used to it now, which I'm actually glad that I'm not used to it. Because if I were, I don't think I'd be the same person that I am.
Mr. Depp, did there come a time when you became passionate about acting?
Once I realized that that's the road that I was on, and that any attempt at going back to music would be it would have been. I hated the idea that since the television series had come out and I had been exposed as this character or this actor, I had to realize in my own mind and heart that there was no going back to music, because I didn't want to, you know, I didn't want to use whatever amount of success that I had attained from the TV series and that sort of thing. I didn't want to use that to influence, some career in music. I had far too much respect for music than to just become what they wanted me to become, which was a teen idol or a teeny that sort of thing. I fought that with everything in my being. So once I realized that music was no longer an option, then I began to study at various places. The Loft Studio, which is now long gone, in Los Angeles. I studied with some other teachers, Saunders Seacat. I read all the books that you could read, and all that was great, but you realize that the only way to learn, or the only way to learn how to, it's not act necessarily, the only way to learn how to react and behave, because it's just behavior and it's reaction, was to do it. It's on the job training, it's trial by fire. So I did my best to work up my own approach towards a character and such.
And what were a couple of the first few projects that you worked on where you were really able to implement that approach?
I would say that the first film that I had done, that I really took, where I really felt, okay, I've done the work, I know what I need to do. I would say that where I considered myself an actor, I suppose, was when Oliver Stone cast me in Platoon in 1986.
How did you come to be cast in Pirates of the Caribbean?
Well, that's many years later, but I had been, Disney had offered me a film called Hidalgo, when it was about a man and his horse in the desert and stuff, and I read the screenplay, and I just didn't think it was for me. But I wanted to have a meeting with them because at that point I had a 2-year-old, 2.5-year-old daughter, and so, or 3, and for 3 years I watched nothing but animated films, cartoons from Tex Avery to Bugs Bunny to that was all I watched with my little girl, and I received the screenplay for Pirates, and it was I somehow in my mind I saw this opportunity, like a way to mesh characters like cartoon characters. For example, Wile E. Coyote gets a boulder dropped on his head and he's completely crushed, but they cut to the next scene and he's just got a little bandage on his head. So I started thinking about the parameters that were available to cartoon characters, and if they were available to cartoon characters, and nobody ever asked a question, whether you were 5 or 95, you didn't ask a question. Oh, Wile E. Coyote, of course he's still alive. So I tried to incorporate these kind of ideas into the character of Captain Jack Sparrow, so that I could try to push those parameters and control the sort of suspension of disbelief, to be able to control the characters' actions, words, movements, and put them in a place where the things that he would do or say were so either ludicrous or mainly something that also something the cartoon characters can get away with things we can't. Captain Jack Sparrow can do things that I could never do. He could say things that I could never say. So it was for me a way to stretch the parameters of a character and take a risk. In doing that, but if it panned out, and I felt I was on a pretty good mission. If it panned out, I thought that it might be a character who would be accepted by 5-year-olds and 45-year-olds and 65-year-olds and 85-year-olds, and in the same way that Bugs Bunny is,
You mentioned
believed.
You mentioned that you received the script. When was that?
I'm sorry?
When did you first receive the script for Pirates of the Caribbean?
The first screenplay I received was 2002, I believe. Yeah, 2002.
And what did you think of that script when you received it?
I thought that it had all the kind of hallmarks of a Disney film. That is to say, a kind of a predictable 3-act structure, with and the character of Captain Jack was more. He was more like a swashbuckler type that would kind of swing in shirtless and, be the hero. And I had quite different ideas about the character, so I incorporated my notes into character and brought that character to life, much to the chagrin of Disney initially.
Now, when you say you made changes to the character, how did you do that?
Just, in preparation, the very same way that I've ever approached any character. You look for a back history. You base it on, it could be anything. Like Edward Scissorhands, for example, I based on a dog that I'd had and newborn babies. My sister had a couple of new babies, and I watched them, because I thought that Edward would see things from the sort of from a place of innocence, and not knowing exactly what things meant or were, and also that look of a pure, innocent child when they experience something for the first time. Those were the two main ingredients that I thought would serve the character.
All right, so yeah, that was the Johnny Depp trial reaction. It's you see his beginning that he had, in his into the point where he does the acting, and kind of like a rough history about how he did different characters. And I've seen it before, but yeah, it's interesting to see how he used different inspirations for different characters from cartoons he watched. Everything has an origin from somewhere, and the struggles he went through, and I think he presented himself very well. Much different than Amber Heard did. And this will conclude the stream for the night, which we had a nice active stream today. We've been going for 6 hours. It's pretty cool. And so we'll be ending the stream, and I want to thank you all for those that are lurking, those that were here earlier, those that are around seeing it as a replay. I want to thank you all for being here and working together and hanging out with me. And see you all tomorrow. Hope everybody has a good evening, and peace.